Contempt ಏನು urgency ಇರ್ತದೆ brother?
Moraji Desai residential schools alli, the teachers has been relieved, Your Lordship.
Relieved.
The specific order is to not to relieve and continue the petitioner to the present place.
Pending matters.
Please, my lord.
ಮತ್ತೆ ಅಲ್ಲೇ ಹೇಳ್ಬೇಕು ಅವರಿಗೆ. ನಾವೆಲ್ಲ ಅಂತವೇ ಮಾಡ್ತೇವೆ. ಪೆಂಡಿಂಗ್ ಮಾಡಿದರೆ ರಿಲೀವ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರು ಡೋಂಟ್ ಹಿಯರ್ ದೆಮ್, ಸ್ಟ್ರೈಕ್ ಆಫ್ ದೇರ್ ಡಿಫೆನ್ಸ್. ಇವೆಲ್ಲ ಪ್ರಾವಿಷನ್ಸ್ ಆಫ್ CPC ತುಂಬಾ ಜನ ಉಪಯೋಗಿಸ್ತಾ ಇಲ್ಲ ರಿಟ್ ಜುರಿಸ್ಟಿಕ್ಷನ್ ದಲ್ಲಿ. ರೆಗ್ಯುಲೇಷನ್ ರಿಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ರೂಲ್ಸ್ 1977 ರೂಲ್ 39 ಅಪ್ಲೈಸ್ CPC. ಹಂಗಾಗಿ ಸ್ಟ್ರೈಕಿಂಗ್ ಆಫ್ ಡಿಫೆನ್ಸ್ ಇದನ್ನೆಲ್ಲ ಉಪೇಕ್ಷಬೇಕು ರಿಟ್ ಜುರಿಸ್ಟಿಕ್ಷನ್ ದಲ್ಲಿ.
Specific directions to continue the petition in the present place.
ಯಾವಾಗ ಹಾಕಿ
an unnumbered writ appeal, my lords, for Monday.
ಯಾವುದು?
An writ appeal wherein, my lord, civic community site allotted to MIWA has been cancelled and it is ordered to be granted to the petitioner on Monday, my lords.
ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಅಂದ್ರೆ ಮತ್ತೆ ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಯ್ತು ಅಂದ್ರೆ ನಂದು ಹೋಗ್ಬಿಡುತ್ತೆ Monday.
Owners appeal, my lords. Owners appeal MFA. EP is filed, my lords, on Monday.
EP is filed. Please, my lords.
Contempt petition, fresh matter, my lord, for preliminary hearing.
After vacation.
My
lord, one.
Please.
My lord, a memo for being spoken to, that your lordship allowed the, my lord, appeal for enhanced the compensation and then directed to pay it within a period of 3 months. Within a period of 3 months ಅಂತ ಬಂದಿದೆ, pay ಅನ್ನೋ ವರ್ಡ್ ಮಿಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಷ್ಟೇ. ವರ್ಡ್ ಅಷ್ಟೇ
ನೋಡಿ, ಚೇಂಬರ್ ಕರೆಕ್ಷನ್ ಪೇ ಅಂತ ಹಾಕಿರ ಚೇಂಬರ್ ಕರೆಕ್ಷನ್ ಗೆ ಆರ್ಡರ್ ಅದು ಪೋಸ್ಟ್ ಮಾಡಿಸ್ತಾರೆ.
Contempt for revival, my lords.
ರಿವೈವಲ್.
Lordship have closed the contempt on 1st August.
ರಿವೈವಲ್ ಅಂದ್ರೆ ಮತ್ತೆ ನಮ್ಮ ಮುಂದೆ ಬರ್ತದೆ ಅದು.
Yes, my lords. My lordship have closed it as they are going to comply it. They have passed in order, but they did not yet, my lord, paid the amount which is due under that order.
Last line.
MFA, my lord. Preliminary hearing.
Preliminary MFA.
Please.
Sorry. Admission ಅನ್ಬೇಕು. MFA preliminary hearing ಬರಲ್ಲ. Yes.
Land acquisition matter, my lords. Land acquisition matter. There are 33 appeals, my lords, which were filed, which were heard, my lords, and this honorable court was pleased to grant an interim order of stay subject to a deposit of 25%. At 25% of the amount is also withdrawn by the farmers, but stay, my lords, is in operation. But out of the 33 appeals, my lords, there were 3 more appeals, my lords, which were left out. There is no interim order. So similar order, my lords, has to be passed for depositing that amount, and matter has to be attached with those. Monday.
ನಾಳೆ ಇರಂಗಿಲ್ಲ,
ಸ್ವಲ್ಪ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ, ಕಂಪ್ಲೈ ಮಾಡಿ.
ಹೆಂಗೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರು ಹಾಗೆ ಪೋಸ್ಟ್ ಮಾಡಿ ನಾಳೆ ಹಾಕಿ ಇರ್ಲಿ. ಮಂಡೇ ಆಫೀಸ್ ಆನ್ಲೈನ್ ಬಾ. ಆ ಆರ್ಡರ್ ಕಾಪಿನೂ ಇಡಬೇಕು, ಮೊನ್ನೆ ಮಾಡಿದ್ದು.
List to serial number 13, my lords.
Within time ಇದೆಯಾ?
What has happened? Registry, as per registry, it is 62 days. According to me, it is 61 days, and previous day is Sunday.
61 days.
61 days ಬರುತ್ತೆ. Previous day is Sunday. I have filed it on Monday. My lords, it may be. I will clarify the registry in this regard. 62. 13, my lords.
HCGP ನೋಟಿಸ್ ಆಗುತ್ತೆ. ನಾವು ನಿಮ್ ಸಲುವಾಗಿ ಅಷ್ಟು ಸಿಗ್ನೇಚರ್ ಮಾಡೋದು 3 ದಿವಸ ಹಿಡಿತು. ಎಲ್ಲ ಸಪರೇಟ್ ಆರ್ಡರ್ಸ್ ಮಾಡಿದೀವಿ ಅಂತ.
List 3. List 2.
In terms of that judgment.
Please, page number 407.
ಅಲ್ಲೇ ನಿಮ್ಮ ಅಪೀಲ್ ನೆಗೆಟಿವ್ ಮಾಡಿದಾರ.
My lord, what happened was the learned single judge, my lord, followed Ganpati Delcom.
Correct.
My lord, which my lord, wherein Apex Court held that the act to amendment would be acting would be prospective in nature, and the transactions, my lord, which are done before 2016, my lord, will not be hit by the amendment. Then, my lord, in view of the review petition, my lord, which is pending before the Apex Court, we just to keep the matters alive, my lord, we have filed it. My lordship
review dispose of ಆಯ್ತು.
ಆಗಿಲ್ಲ
ಇನ್ನು ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್.
Still pending. ಆದ ಕಾರಣ
ಹಾಗಾಗಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ಔಟ್ಕಮ್ ಆಫ್ ದ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಂತ ಮಾಡಬೇಕಾಗುತ್ತೆ.
We may be given liberty to recall, my lord. Then we'll argue on the delay limitation, everything we'll argue.
Page number ಯಾವುದು?
My lord, 407, my lord.
407.
Seven. Writ appeal matter 1060. My lord, the last sentence, my lord, condonation of delay, that issue may be kept open, my lord, we'll argue. Seems to be an error, my lord. Recalling ಅವಕಾಶ ಕೊಟ್ಟಿದ್ದಾರೆ, but
The subject matter of, ಇದೇನ್ separate ಆಗಬೇಕಾ ಒಂದೇ ಆರ್ಡರ್?
separate.
The subject matter of this appeal is substantially similar to the one in writ appeal number 1060 of 2023, which has been heard and decided by a coordinate bench of this court, wide order dated 8/2/2024. First one. Next paragraph. The short order comprising of two paragraphs, two small paragraphs, comma, for the ease of reference, is reproduced below. 409. Next paragraph. It is a cardinal principle of adjudication that like cases should be decided alike unless there are repugnant circumstances. First up, no repugnant circumstances are noticed from the perusal of records. First up. The learned panel counsel appearing for the revenue in appreciable fairness submits that these appeals should also meet the same fate. Of course, subject to outcome of review. Yenadu review?
Review petition, my lord.
In Union of India versus Ganapati
Dealcom Private
Limited. SLP number ಏನ್ರ ಇದೆಯಾ? ಅದು SLP ಬರಲ್ಲ ಅದು. ಅಲ್ಲ, it is put off. ಇದ್ರ ಮೇಲೆ review ಇದೆ.
This is another matter, my lord, which wherein this matter is referred to. My lord, last two lines, my lord.
In civil appeal numbers 5783 of 2022, connected with along with SLP bracket ನಲ್ಲಿ C ಅನ್ಬೇಕು. ಒಂದನೇದಕ್ಕೆ ಏನಿಲ್ಲ, C ಎಲ್ಲ ಎರಡನೇದಕ್ಕೆ SLP C number 2784 of 2020, which are stated to be pending on the file of Apex Court. First up. Next paragraph. In view of the above, comma, these appeals with the above observations are dismissed. This appeal ಅನ್ಬೇಕು, ಎಲ್ಲ ಬೇರೆ ಬೇರೆ ಆರ್ಡರ್ ಮಾಡಬೇಕು.
Lord, may I make one submission, my lord? The last sentence of the order judgment says, my lord, consequently the IAN number so and so, condonation of delay also stands dismissed, a previous order only. They have given us liberty to recall.
However, no order is made on the application seeking condonation of delay which accompanies the belated file appeal belatedly filed. All kadi sentence.
My lord, may I make one submission? There are 24 matters, my lord. But
ಕೊಡಿ.
they are all in compliance.
ಕೊಡಿ ಅಟ್ಲೀಸ್ಟ್ ಅವು ಮುಗಿದ್ರೆ ಬೇರೆ ಕೇಸ್ ಕಡೆ ನಾವು ಅಟೆನ್ಷನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಸುಮ್ಮನೆ ಸ್ಟಾಟಿಸ್ಟಿಕಲಿ ಸೋ ಮೆನಿ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಪೆಂಡಿಂಗ್ ಅಂತ ಎಲ್ಲ ಬರೆದು ಹಾಕ್ತಾರ ನಮ್ಮ ಮೇಲೆಲ್ಲ. ಮಧ್ಯಾಹ್ನ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೋಣ, ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ತಾನೆ?
Same order.
ನೋಡಿ ಆಗ್ತದೆ, ಯಾಕೆ ಆರ್ಡರ್ ಶೀಟ್ ಆರಾಮ್ ಮಾಡಿಕೊಡಿ ನೀವು. ನಾಳೆ ಮಾಡ್ತೀರಾ? DCF ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಬೇಕಲ್ಲ, ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ has to pay court
We
fees to the
have
state.
paid.
ಮಾಡಿದ್ರಾ?
ಹೌದು.
ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ panel counsel submits that DCF is made good. ಅದು ಯಾವ್ದಾದ್ರಲ್ಲಿ ಇದೆ ಅಲ್ಲಿ ಮಾಡ್ಕೋಬೇಕು ಈ ಆರ್ಡರ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
List 1. Orders matter. In the hearing 1, SP Dharwad.
ಹಾ, ಏನ್ ದೊಡ್ಡಗೌಡ್ರು ಇದು?
Please.
Yes, pursuant to
Petitioner is the father of the detainee lords.
no, concerned
ಬಂದಾರಾ?
Bandidar investigation officer are present
Ah.
and they have conducted investigation pursuant to the complaint filed by the father of the detainee. Thereafter, my lord, after taking into consideration all the factors which has to be considered with regarding to enquiry, with regarding to the mobile status, as on the last date when the both the
ಅಲ್ಲ, ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಆಗಿದೆಯಾ?
illa
ಇನ್ನೂ ಸಿಕ್ಕಿಲ್ಲ,
innu sikkilla,
ಆ ವ್ಯಕ್ತಿ ಸಿಕ್ಕಿಲ್ಲ.
innu sikkilla.
ನೋಟಿಸ್, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್.
Please.
ಯಾಕೆ ಎಲ್ಲಿ?
Sorry, it is daughter, it is changed as husband.
Daughter.
ಇಲ್ಲ, ಡಾಕ್ಟರ್ ಆಗ್ಬೇಕು, ಹಸ್ಬೆಂಡ್ ಆಗಿದೆ ಅಷ್ಟೇ. No, no, the entire ground is, I'll withdraw. Please, sorry.
ಇಷ್ಟೊಂದು ಸರಿ ಮಾಡ್ಕೊಂಡು ತೆಗೆದು.
Please, I will withdraw that ground.
Counsel with the leave of the court has struck off ground number 4. There being no objection from the other side, from the HCGP, from the side of HCGP. From the side of respondent. Notice,
Yes.
who has accepted, who has accepted notice on request this day. ಬನ್ನಿ, ಇದೇನಾಗಿದೆ? ಎಲ್ಲ ಇವೆಲ್ಲ ಪಂಚವಾರ್ಷಿಕ ಯೋಜನೆನ ಏನು ಹುಡುಕೋದು?
ಇಲ್ಲ
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತಾ ಇದೀವಿ ಸರ್.
ನಿಮ್ಗೆ ಎಷ್ಟು ದಿವಸ
ಸರ್ ಅವನು
ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹುಡುಕಕ್ಕೆ? ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ, ಇನ್ನೊಂದು 15 ದಿನ ಅವಕಾಶ ಕೊಟ್ಟರೆ ಹೋಗ್ತೀವಿ ಸರ್. ಯುಪಿ ಮತ್ತು
ಏನ್ರ ಕ್ಲೂ ಸಿಕ್ಕಿದೆ?
ಏನು ಕ್ಲೂ ಏನಿಲ್ಲ ಸರ್. ಬಟ್ ಅವ್ನು ಯಾವ್ದೇ ರೀತಿ ಮೊಬೈಲ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸರ್. ಬಟ್ ಅವನು ಈ ರೋಡ್ ಅಲ್ಲಿ ನೀರಿನ ಬಾಟಲ್ ಅದು ಇದು ಮಾಡೋ ವ್ಯಕ್ತಿ ಸರ್. ಎಲ್ಲ ಟೆಕ್ನಿಕಲಿ ಯಾವ್ದೋ ಒಂದು
ಯಾರು ಕರ್ಕೊಂಡು ಹೋಗಿಲ್ಲ ಅವ್ರ ಜೊತೆನು ಅವನು ಸಿಕ್ಕಿಲ್ಲ?
ಇಲ್ಲಿ ಸಿಕ್ಕಿಲ್ಲ ಸರ್. ಮತ್ತೆ IMEನು ವರ್ಕ್ ಆಗ್ತಾ ಇದೆ ಸರ್. IP ಅಡ್ರೆಸ್ ಎಲ್ಲ ಕೇಳಿದ್ವಿ ಸರ್. ಅದು ಯಾವ್ದು ನಿಲ್ಲದ ಸರ್. ಆಧಾರ್ ಲಿಂಕ್ ಇದ್ದು ಸಿಮ್ ಯಾವ್ದಾದ್ರು ತಗೊಂಡಿದ್ರೆ ಆಧಾರ್ ಸಿಮ್ ನಿಲ್ಲದ ಸರ್. ಯಾವ್ದು ಸಿಮ್ ಯೂಸ್ ಮಾಡಿ
ಆಗಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್ ಮುಗಿತಾ ಬಂತು.
ಆಮೇಲೆ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ನೋಡಿದ್ವಿ ಸರ್. ಯಾವ್ದು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್ ಇಲ್ಲಿ.
ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ you know what orders we will make. We will direct suspension of the concerned officer. ನೀನು ನಿನ್ ಮೇಲಿನ ಸರ್ಕಲ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಇಬ್ಬರನ್ನು ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. ಈಗ ಮಾಡಲ್ಲ, ಇಮಿಡಿಯೇಟ್ಲಿ ಈಗ ನೋಟಿಸ್ ತೊಳಿ ಮಾಡಲ್ಲ. ಅವನ್ನೆಲ್ಲ ಏನ್ ಹೇಳ್ಬಾರ್ದು. ನಮ್ ಸಿಕ್ಕಿಲ್ಲ ಮಾಡಿಲ್ಲ ಮತ್ತೆ ನೀವೇ ಅದಕ್ಕೆ ಬೇಕು. ನಮ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಏನ್ರ ಬೇಕಲ್ಲ ರಿಪೋರ್ಟ್. ಇದೇನ್ ಬೇರೆ ದೇಶಕ್ಕೆ ಓಡೋಕ್ ಸಾಧ್ಯ ಏನು? ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ತಂದು ಕೊಡ್ಬೇಕು, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು. ಅದರ್ವೈಸ್ ವಿ ಮೇ ಡೈರೆಕ್ಟ್ ಸಸ್ಪೆನ್ಷನ್. Tell your inspector why he has not come. In all habeas corpus matters, minimum the attendance is minimum of circle inspector. Why he is coming?
Any date may kindly fix, Lord. Any date, next date. Please.
14th ಕೊಡಿ. 14th ಗೆ ಇರಬೇಕು ಆ ಪರ್ಸನ್ ಇಲ್ಲಿಗೆ.
Please.
2. AP Patil, stringent orders may be passed against the concerned police officials in the event the missing person is not traced or any information as to his whereabouts or is not placed on record. Yes,
Please.
2. AP Patil.
Parties are present, Your Lordship.
Anything.
They are ready to reunion.
you are agreeable for
Yes.
reuniting?
Both are present.
Ibru idara?
Yes, Your Lordship.
ಇಬ್ರು ಮತ್ತೆ ಜೊತೆಗೆ ಇದ್ಕೊಂಡು ಖುಷಿಯಿಂದ ಇರ್ಲಿ. ಒಂದು ಎಲ್ಲರ ಕೈಯಿಂದ ಚಪ್ಪಳಿಕೆ ಕೊಡಿಸ್ಬಿಡ್ತೇವೆ ಒಂದು.
My lords, I am filing wakalat for respond. And
Due respect, my, yesterday review petitions filed before the apex court, my lord.
Yesterday,
Review petitions filed,
review.
review is filed.
Why party is not present
Oh,
before?
he is present.
ಎಲ್ಲಿದ್ದಾರೆ?
He's there, he's there.
ಅಲ್ಲಿ ಕುತ್ಕೊಂಡ್ರೆ ಹೆಂಗ್
Sorry,
ಗೊತ್ತಾಗಬೇಕು?
sorry, sir.
He is an accused, he should stand here.
Sorry, sir.
Order ಯಾರ್ದು?
Pardon?
6th of April 2023.
Yes, ma'am.
Ah.
Writ appeal was filed. Writ appeal also dismissed. And against
SLP
SLP is
dismissed.
filed, SLP dismissed.
Then again review is
Now
filed.
review is filed.
You comply with this order, subject to outcome of the review.
Let
Ask
him,
him, ask him whether he wants to do it or not. Yes.
Submission, my lord.
Ah.
Sir, there is no statutory provision for that.
All that has been argued. You lost before the single judge, you lost before the division bench, you lost before highest court of the country. Now again you have filed review. You maintain review. We are not against that. First comply with this order. People may lose faith in us. Already they have lost faith in us now. First comply with this order. When are you going to comply? That will be subject to, in Kannada, English.
Kannada,
ಕನ್ನಡ ಬರ್ತದ? ಈ ಆರ್ಡರ್ ನೀವು ಈ ಆದೇಶ ಏನಿದೆ ಅಲ್ಲ, 3 ಆದೇಶಗಳು ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಇರುವಂತವು. ಈಗ ಮೊದಲು ಆ ಆದೇಶವನ್ನು ಪಾಲಿಸಿ, ಅದಾದ್ಮೇಲೆ ರಿವ್ಯೂ ನೀವು ಸಕ್ಸೀಡ್ ಆದ್ರಿ ಅಂದ್ರೆ ನಂತರ ಅದು ಕ್ಯಾನ್ಸಲ್ ಆಯ್ತು. ಅದನ್ನ ಬರೆದು ಬಿಡ್ತೀವಿ. ಯಾವತ್ ಮಾಡ್ತೀರಿ? ನಾಳೆ ಕರಿಬೇಕಾ?
ಈಗ ನಮ್ಮ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಇರುತ್ತೆ.
ಯಾವ ಬೋರ್ಡ್? ಯಾವ ಬೋರ್ಡ್ ಇಲ್ಲ. ಕೋರ್ಟ್ ಹೇಳ್ತು ಅಂದ್ರೆ ಬೋರ್ಡ್ ಗಿರ್ಡ್ ಕಿತ್ಕೊಂಡು ಹೋಗ್ಬೇಕು, ಸುಮ್ಮನೆ ಮಾಡ್ಬೇಕು, ಕಾಂಪ್ಲೈ ಮಾಡ್ಬೇಕು. ಬೋರ್ಡ್ ನಲ್ಲಿ ಇಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅದು. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮತ್ತೆ ಇನ್ನೊಂದು ಅಪ್ರೂವಲ್ ಬೇಕಾ? Then what is fun in having the court order? We are calling this matter on. You do it and take post facto approval if it is necessary. We will say that approval of the board is not necessary. Barkali. The commissioner,
Buda.
Belgaum Urban Development Authority, who is personally present before the court pursuant to our order dated 23/9/2024, submits that a review has been filed in the writ appeal.
In the SLP.
In the SLP.
SLP ದಲ್ಲಿ review ಆಗಿದೆ.
SLP, which has been dismissed by the apex court. First, pendency of review is too poor a ground for not complying with the orders of court. Full stop. Therefore, as a last chance, the respondent commissioner is granted 3 days for executing and registering the sale deed, subject to outcome of the review, failing which he may run the risk of arrest and detention. Call this matter on Tuesday. First.
Please.
For accomplishing this task, there is no need for approval of anyone, including the board.
Yes, please.
Yes. Board stroke authority. Yes. For government?
2 days time to take process insofar as respondent number 3 is concerned.
When you were supposed to?
Not already 2 times we have taken.
You have taken already?
Yes, state appeal. State.
My lord, one submission, my lord. Since 2012, I have not received salary, my lord. And though there is a direction by the honorable single judge, till they are not deposited or paid me, and there is a delay of 261 days in filing this appeal.
You deposit that money here. Yes. We will not release. You deposit here, then we will grant time.
Yes. By the next Monday.
Learned government advocate is told to tell his clients to deposit the arrears of salary in the registry of this court. As a precondition, immediately as a precondition for entertaining the request for grant of time to pay the process.
Please.
Failing which, the appeal stands rejected. Call this matter on Tuesday.
Please.
On Tuesday. First appeal runs the risk of rejection. Yes.
Please. By Waqar Ahmed.
Yes. Waqar Ahmed.
Father is present, sir.
Father is present.
Yes.
Madam.
She is respondent and
Respondent.
female child is.
I pay for the bank. Since he has, my lords, already, my lords, filed an affidavit. Complying with the terms of, my lords, the compromise that was entered into before the lords.
When are you going to execute the sale deed?
It's a week's time, my lords, we only require.
Monday, Tuesday. When we go back,
Please,
we will not leave anything here.
In fact, my lords, we had written a letter.
They have to only return the title deeds, original title deeds.
ನಿಮಗೆ ಕೊಡಬೇಕು.
ಹೌದು.
ಕನ್ವೀನಿಯನ್ಸ್ ಮಾಡೋದು ಬೇಡವಾ?
ಇಲ್ಲ, ನಾನು ಮಾರ್ಟ್ಗೇಜ್ ಮಾಡಿದ್ದೆ.
That's all. ಮಾರ್ಗೇಜ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಮಾರ್ಟ್ಗೇಜ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಮಲೋಡ್ ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಕ್ಕೆ ಅವರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್. In his
We
affidavit.
were only awaiting, my lords, confirmation from the auction purchaser that no, in view of the affidavit, my lords, we'll go ahead, my lords.
ನಾಳೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡು ಮಂಡೇ ಬರ್ಬೇಕು. ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲ ಹರಾಸ್ ಮಾಡೋದು litigants ಅನ್ನ.
Respond number 1.
Respond.
To report the compliance list on Monday.
Please. The certified copy of this order, my lords.
Then council.
SB Patilers.
And council appearing for the respond number 3.
Accused number 3.
Affidavit indicating that he has no objection to cancel the sale certificate and hand over the title deeds in respect of the assets of mortgage in favor of the complainant. Said submission and affidavit is placed on record. In view of the said affidavit, the accused number 1 shall take steps forthwith and report the same to this court on Monday.
Please. If this order is web hosted, if this order is web hosted, my lords, I'll communicate to the bank and my lords will get it done.
ಅದೇ ಇವತ್ತೇ ವೆಬ್ ಪೋಸ್ಟ್ ಮಾಡ್ಬಿಡ್ತೀವಿ.
Please, great.
ಎಲ್ಲ ಆರ್ಡರ್ಸ್ ವೆಬ್ ಪೋಸ್ಟ್ ಮಾಡಿ ಎಕ್ಸೆಪ್ಟ್ ಲಾಂಗ್ ಆರ್ಡರ್ಸ್ ಅಷ್ಟೇ.
Handing over the title deeds, sir.
Please, my lords. We have to measure.
ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ಲ ಅನ್ನೋದು.
ಇಲ್ಲ ಇಲ್ಲ.
Sale certificate.
ಇಲ್ಲ.
ಕರೀರಿ ಬ್ಯಾಂಕ್ ಅವ್ರನ್ನ ಕರೀರಿ ಮಧ್ಯಾಹ್ನ. ಕರ್ಕೊಂಬರ್ರಿ.
The sale certificate, my lords, in favor of.
Ask your bank manager to bring all that.
Please.
Please. Client ಹೋಗಂತ ಹೇಳಿದ್ದಾರೆ.
ಗದಗ.
ಕರ್ಕೊಂಬರ್ರಿ.
ಇಲ್ಲ ಇದ ನಮ್ಮ ಕ್ಲೈಂಟ್. I'll send him. ಅಲ್ಲಿಗೆ ಕಳಿಸ್ಬಿಡ್ತೀವಿ ಕೊಳ್ಳಿ ಅವರು.
ಅಲ್ಲಿ ಕೊಟ್ಟು ನಮ್ಗೆ ಅದು ವಾಟ್ಸ್ಆಪ್ ಇದರಲ್ಲಿ ಒಂದು ವಿಡಿಯೋ ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ನಮಗೆ ತೋರಿಸ್ಬೇಕು.
Please.
ದಟ್ ಇಸ್ ದ ಓನ್ಲಿ ವೇ ಈಗ. ಅದರ್ವೈಸ್ ಕೇಸ್ ಆರ್ಡರ್ಸ್ ಯಾರು ಫಾಲೋನ ಮಾಡಲ್ಲ. ಪ್ಲೀಸ್. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ.
7. Mahesh
That's appear for the petitioner. My lord, the office notice that my lord.
ಪಾಸ್ವರ್ಡ್.
7.
My lord, appear for the petitioner. The office note that my lord, I have made only respond number 3 and 4 who are the implementing authorities in the contempt petition. The others are not made a party.
Office objection is explanation having been accepted. Office objection is rendered infructuous. ಏನಿದು
My lord, so the learned single judge, my lord, restore the, my lord, the entries made by the, my lord, the assistant commissioner.
One submission. Page 19 may kindly be seen.
19.
Yes.
At para 6 of the learned single judge order.
Entries.
But there is no direction in so far. There was a direction directing us to file.
Now that is the change of entry happened pursuant to order of the deputy commissioner.
Yes, sir.
That is set aside.
Yes.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಕೇಸ್ ಬೇಕಾ? Order may not be that way. But where is the requirement of another? Court order should be interpreted with common sense.
That is true, my lord.
When ಬೇಕಿಲ್ಲ. ಅಷ್ಟೇ. But orders of the court, apex court said in ಅದು Madhav Scindia versus Union of India.
Yes.
Everybody should interpret orders of the court with common sense. Common sense should not, I am reproducing the sentence now.
Yes.
Common sense should not be kept in cold storage while construing the orders of court. A sentence ಇದೆ.
File memo Monday.
Monday file ಚೇಂಜ್ ಮಾಡಿಬಿಡ್ಬೇಕು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದ್ದಾಗನೆ. ಯಾವ್ದು ಅಪೀಲ್ ಯಾವ್ದು ಮಾಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇನ್ನೂ ನೋಟಿಸ್ ಆಗಿಲ್ಲ. ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದು. ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದು.
ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಅಂಡ್ ವಿಲ್ ಟೇಕ್ ನೆಸೆಸರಿ ಸ್ಟೆಪ್ಸ್. Yes.
20
ಸಿವಿಲ್ ಹಂಗಾಗಿ ಏನು ವಿದೌಟ್ ಇದನ್ನು ಕೊಡಬಹುದು. ಸಿ ಅಕ್ಸೆಪ್ಟ್ಸ್ ನೋಟಿಸ್.
With the lordships.
Then you give instruction ತಗೊಳ್ತೀರಾ?
ಅಲ್ಲ ಐ ವಿಲ್ ಗೆಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂಡ್ ಮೇಕ್ ಸಬ್ಮಿಷನ್ಸ್.
Just on Monday.
Yes, with the lordship's kind permission. Serial number 23 is also same. Same.
ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಾಂಪ್ಲೈ ಮಾಡಬೇಕು. ನಮಗೆ ಭಾರಿ ಸಿಟ್ಟು ಬರ್ತದೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಾಂಪ್ಲೈ ಮಾಡ್ಲಿದ್ರೆ. ರೈಟ್ ಆರ್ ರಾಂಗ್ ಆರ್ಗ್ಯೂ ಮಾಡಿ, ಬಟ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಕಾಂಪ್ಲೈ ಮಾಡಿ. ಏನದು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಟ್ ಹಾಕ್ಸ್ಕೊಂಡು ಇಡ್ಬೇಕಾ ಮನೆಯಲ್ಲಿ? ಕಾಂಪ್ಲೈನ್ಸ್ ಆಗ್ಬೇಕು, ಮತ್ತೆ ಅದಕ್ಕೊಂದು ಕೇಸು, ಅದ್ರ ಮೇಲೆ ಒಂದು ಅಪೀಲು. ಏನ್ ಎಂಡ್ಲೆಸ್ ಲಿಟಿಗೇಷನ್ಸ್. ಗೌರ್ಮೆಂಟ್ ಮೊದಲು ಫಾಲೋ ಮಾಡ್ಬೇಕು, ಆಮೇಲೆ ಸಿಟಿಜನ್ಸ್ ಎಲ್ಲ ಫಾಲೋ ಮಾಡ್ತಾರೆ. ಮಂಡೇ ಮಾಡ್ಕೊಂಡು ಬರ್ಬೇಕು. ವಿಲ್ ಕ್ಲೋಸ್. ನೀವು ಅದನ್ನ ಹೇಳಿದ್ರೆ ಮಾಡಿ ಹಾಕ್ತೀವಿ, ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಂತದ್ದು ಏನಿಲ್ಲ.
ಪ್ಲೀಸ್
ಅಷ್ಟೇ.
Monday ಇರಲಿ. ಅಷ್ಟೇ ಕೇಳಿ ಹಾಕ್ತೀವಿ.
In serial number 8, my lord, the respondent accused has filed an application for recalling of NBW order. Lord, with regard to that compliance, my lord, copy was not served to the other side. I have served the copy. That is the objection which has been raised.
Recalling order. ಯಾರು ಆಫೀಸರ್?
Officer.
ಯಾರಿದ್ದಾರೆ?
He is present before the
court. He is present before the court now.
Yes, ma'am.
But why he did not come other day?
My lord, on that day, the Tahsildar who is now against whom the NBW has been issued, he was transferred prior to the issuance of notice in the contempt petition, and he has taken.
No. All right.
That is part of the affidavit.
ಆಯ್ತು, ಏನಿದೆ ಆರ್ಡರ್ ಏನಿದೆ?
My lord, now one more submission.
Mutate the entries of the petitioners to an extent of 36.84 acres in the revenue records in respect of land so and so at Rameshwara Bandi, Agribammanahಳ್ಳಿ ತಾಲೂಕು, after deleting name of government ಅಂತ ಆರ್ಡರ್ ಇದೆ.
ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿದ್ದೇವೆ.
ಮಾಡಿದಿರಾ?
ಮಾಡಿದೆ. 100498.
The NBW is recalled after noticing personal presence of the Tahsildar.
Yes.
Jurisdictional Tahsildar, who assures that hereafter he should be scrupulously obeying the orders of the court. First off, we are told that appeal is filed against the order whose violation is complained of in writ appeal number 100. So, first, call this matter along with the said appeal,
please,
in the third week of October. Yes.
100498.
9, Taltili.
Lord, in this, on the last occasion, the Lord's concerned learned AG appeared in this case and submitted before the Lordship that in with regarding to deemed conversion provision, direction has been issued by the learned single judge. Now, government order has been issued to file appeal challenging the order passed by the learned single judge.
Appeal is filed?
ಅಲ್ಲ ಅಪೀಲ್ ಮಾಡ್ತೇವೆ, ಬಂದಿದೆ ಇವತ್ತು ಗವರ್ನಮೆಂಟ್.
ಮಾಡ್ತೀವಿ ಅನ್ನೋದ್ರ
ಅಲ್ಲ ಇವತ್ತು ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್
ಕಾನೂನು ಬದಲಾಗ್ತದೆ ಅನ್ನೋದ್ರ ಮೇಲೆ.
No, today we have received the government order to file the appeal. Within 2 to 3 days, my lord, the appeal will be filed before this.
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಅಪೀಲ್ ಇದೆ.
ಹೌದು, ಮಾಡಿದೆ. Nearly 20 appeals have been filed.
Third week of October, ಕರೆಯೋಣ.
Yes, ma'am.
Learned government advocate submits that order whose violation is complained of is being appealed against shortly.
Please.
First, call this matter in the third week of October.
Please.
Almost,
with contemplated appeal.
almost 1 year has been lapsed. 8 months time was granted for them.
ಅಲ್ಲ similarly ಹಾಕಿ.
ಅದು ಜಸ್ಟಿಸ್ ಚಂದ್ರಗೌಡ್ರ ಸಾಹೇಬ್ರ ಆರ್ಡರ್ ಅನ್ನು.
ಹೌದು. ಅಲ್ಲ ಮೇಲ್ ಮೇಲೆ ಬೇರೆ ಅಪೀಲ್ಸ್.
ಅದೇ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ನೋಡ್ಕೊಂಡು ಅದನ್ನ ಇದು ಮಾಡ್ಯಾರ ಅಪೀಲ್ ಈಗ. 87 ILR. ಚೆನ್ನಾಗಿ ಬರ್ತದೆ. 88 ILR.
10, Shaila Bellikatti.
Yes, Shaila madam.
Challenging the order of the trial court under section 9 of Hindu Marriage Act.
This honorable court was pleased to issue direction to be the respondent to be present before this honorable
ಆಗಿದೆ
court.
ಪೊಲೀಸರು ಆಗಿದೆ ಸರ್ವಿಸ್ ಆಗಿದೆ
And
ಹಾ
even
He has come now.
even appellant is also present, your lordship. This for conjugal rights.
Appellant is present.
Please, shield, sir.
It will be condoned by the
ಹೆಂಗೆ ನೋಟಿಸ್
apex court decision.
ನೋಟಿಸ್ ಇಲ್ದಂಗೆ ಕಂಡೋನ್ ಮಾಡ್ಬೇಕಾ
ಇಲ್ಲ sir.
ನೋಟಿಸ್ ಹೋಗ್ಬಾರ್ದು.
Yes. R1 is the government, sir. If R1 is the private party, R2 is the government.
CGP.
CGP is requested to emergent notice to R1 on IA as well as on NIA.
The writ petition is maintainable in matters
Yes,
like this. Which is that?
2008, my lord, sir. Large judgment decision. 2008, what, copy. Plus, 2008 SCC 660. What? There is statutory bar under Mass 22 of the Legal Service Authority Act.
Short accommodation ಬೇಕು ಅಂತಾರೆ. Immediately.
But he has not appeared before learned single judge.
Not.
Petition is filed by Mass, the purchaser.
Call on 15. Request of counsel.
Let there be, Mass, before learned single judge was interim order. The suppression was
2022 Lok Adalat award
Lok
declared.
Adalat plus by suppressing the fact that I am the power of attorney holder who has got interest in the property. I have invested the amount.
Next.
27 H Bagi.
ಬಗ್ಗೆ ಏನಿದು?
My lords, the petition rejected on the ground that there is a delay to grant the, my lords, ex-serviceman, my lords.
I accept notice for all the respondents.
ಅಷ್ಟೇ.
ಅದರ ಮ್ಯಾಡಮ್ ಕೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ. That is not considered.
ಸರ್ವಿಸ್ಮನ್. ಹೌದು. ಇಂಥವ್ರನ್ನೆಲ್ಲ ಡಿಲೇ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ನಾಳೆ ಅವರು ಬೇರೆ ಅಲ್ಲಿವ್ರು ಏನು ಅನ್ಕೋತಾರೆ.
It is to file statement of objection indicating the availability of land in the places within the taluka/district.
Please.
Please.
ಅಷ್ಟೇ.
Further hearing, appearing for the respondent.
Just thank you for coming here personally.
I'm obliged there. ನನಗೂ ಬಹಳ ದಿವಸ ಆಗಿತ್ತು ಬಂದಿರ್ಲಿಲ್ಲ.
ನಿಮ್ಮಂತರೆಲ್ಲ ದಾಡೋದು ಬರಬೇಕು. ಏನಾಗ್ತದೆ, ಬಹಳ ಯಂಗ್ಸ್ಟರ್ಸ್ ಎಲ್ಲ ಇದ್ದಾರೆ, ನೋಡ್ತಾರೆ, ಮಾಡ್ತಾರೆ, ಕಲಿಯೋದಿರ್ತದೆ. ಅವರೆಲ್ಲ ಬಂದಾಗ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ದವರು ಅವ್ರ ಲೆಕ್ಚರ್ಸ್ ಎಲ್ಲ ಆರ್ಗನೈಸ್ ಮಾಡಿದ್ರೆ ಬರ್ತಾರೆ. ಅನ್ಕೊಂಡು ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಂತಂದ್ರೆ ಅವ್ರು ದೇ ಹ್ಯಾವ್ ಗಾಟ್ ಸಫಿಷಿಯಂಟ್ ಮನಿ ದೇರ್, ಮನಿ ಸಲುವಾಗಿ ಬರೋದಿಲ್ಲ. ಯು ಶುಡ್ ಟೇಕ್ ದೆಮ್ ಟು ದಿ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ and ask them to deliver lecture, their experience in the highest court of the country, various high courts ಹೋಗ್ತಾರೆ. That will help. That helps. Really, that helps. Learning law is more by observation than by reading. Reading is a must, that is one thing. But that is not all. ಹಂಗಾಗಿ ಅಸೋಸಿಯೇಷನ್ಗೆ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಬಂದಾಗ ಆಫ್ ರೆಪ್ಯೂಟ್, such people should be taken to the bar association and they should be asked to deliver lecture. ಆಮೇಲೆ ಕೋರ್ಟಿಗೆ ಕಳಿಸ್ತೀವಿ, ಇಲ್ಲ ಕಳಿಸಲ್ಲ ನಿಮ್ನ ಅಂದ್ಕೊಂಡು ಹೇಳಿ ಬಿಗಿ ಮಾಡ್ಬೇಕು.
In fact, Lord, I have lectures on 5 subjects, Lord, on YouTube. I have a channel called Never Before Legal.
Okay.
I choose this subject which have not been heard by anybody, which are very unique and new concept. One of them was, my Lord, constitutional torts.
Constitutional
torts. Yes.
Torts.
Yes.
300.
Yes. And my Lord,
Father, our professor Sheshadri used to teach P&O steam navigation company in the beginning ಆಗ್ತಿತ್ತು. Reconcil judgment.
And my Lord, political reservation is ultra virus of constitution. Election has to be on the basis of a choice, not by selection amongst few. The matter is, my lord, before the constitution bench. It is, I'm leading, my lord, in one of the matter. Before that, my lord, there is a lecture. And my lord, decriminalization of Negotiable Instruments Act offences.
Like from FERA to FEMA. FEMA. FERA was very, very criminal elements.
Not on that, my lord. If my lords were to see, my lord, 142, it starts with a non-obstante clause saying that notwithstanding anything contained in the Code of Criminal Procedure, the complaint has to be under 142 and the cognizance has to be taken under 142. What is happening, my lord, in the country is people are filing under 200. The moment 200 petition is filed,
all CRPC begins.
My lord, the power of a magistrate emerges. And you will be resorting to
various provisions of the CRPC.
Resorting to sworn statement, thereafter taking cognizance, and party coming thereafter. And by virtue of this, my lord, what is happening is notices are issued through a police, whereas the Act says, my lord, it is this courier and the speed post. If it is resorted to courier and speed post, the police intervention will not be there. The police will come only when there is a conviction.
Not till then.
Not till then.
These are all new things to me. My brother may be knowing.
If my lords were to convince, if my lords are convinced, my lord, of what I have said, a writ of prohibition can be issued against the magistrate not to receive a complaint under 200,
but under
insisted upon, my lord, filing under 142. The court will be
procedure itself.
Yes, the court will be saving, my lord, time on the sworn statement. And there is also one of the aspects, my lord, I have stated in my lecture also. My lord, there is a presumption of the negotiable instrument and, my lord, the banker slip. Correct. The complainant did not prove it.
118.
Yes. It is only for rebuttal of presumption.
He has to lead evidence.
He has to lead evidence. I need not even lead evidence. The matter can be over, my lord, in 3 or 4 sessions.
Not even 3 or only one session only.
Yes.
We take lot of time in these things.
So a lot of time can be saved, my lord, if this mechanism is adopted.
And abuse at the hands of some unscrupulous section of police will also stop.
Yes. And one other subject, my lord, whether India is a republic or a democratic country. People say, my lord, we are
hereditary, everything.
Yes. We are loosely saying that, my lord, India is a democratic country. According to me, my lord, we are not democratic, we are republic. The moment I say republic, my lord, all facets of republic, my lord, comes into operation. And part 3, my lord, is the reflection of republic. And no court has decided, my lord, on this aspect. My lords are familiar with the judgment, my lord, in Keshavananda. If the argument was to be accepted as a republic, but the question of amending power of the parliament will not arise. We will have to go back to people. Somehow the court was in a mood to prevent the parliament from amending the constitution. If this argument was advanced, saying that it's a republic, question of the parliament exercising the power of sovereign.
Constituent power would not.
Sovereign
power, which is with the people.
Yes.
Would not arise.
Yes. In a republic, sovereign power vests with the people.
People, not the.
Yes. Not the parliament.
Parliament.
Slowly we have become, my lord, sovereign, my lord, parliament. They say parliament.
Which runs counter to the constitutional spirit.
Yes. All that, my lord, I have dealt in about 3 episodes. During the pandemic, my lord, I had no work, lot of time was there. I thought I should spend some time, my lord, on this. And I choose, my lord, only subjects which have not been
touched by others.
Yes. Even on
Even
two
in
nation-
argument, you are like that, that's another thing. Yes, sir.
Please. Lord, we have filed written arguments, my Lord, synopsis of our written argument.
Yes.
On 24 September.
Yes.
Lord, I request my Lord to kindly take that.
Yes. '97 section
96, my Lord.
96.
Yes.
Kodi.
My endeavor will be, my Lord, to demonstrate before my lords that after coming into the force of 2013 Act, all state acts providing acquisition, my Lord, are deemed to have, my Lord, repealed. There is only one law in the country which deals
to land acquisition.
land acquisition. That is the principal land acquisition act, my Lord, in the country.
How you form this opinion on what?
254, my Lord, Article 254.
It's concurrent list.
It is in a concurrent list.
So law is, field is occupied.
Yes, field is occupied.
But if it is purely land acquisition, yes. But power to acquire land can be subsidiary to the main object of some other legislation.
My lords will kindly see, my Lord, President assent is taken when a State Highways Act is passed. All that repugnant provisions to the Land Acquisition Act are deemed to have been, my Lord, taken care of. And those repugnant provisions, my Lord, will start operating just like a protected umbrella for all those provisions which are repugnant to old Land Acquisition Act. The moment re-legislation takes place, your lordships are aware, my Lord, 254 subclause 3 proviso, Parliament has the power to re-legislate. The moment it is re-legislated, the President assent, my Lord, will vanish, or, my Lord, becomes redundant. There has to be one more assent of the President, my Lord, to revalidate, or, my Lord, to reenact the provisions. Then only, my Lord, that provision will be sustainable. In one of the judgment, my Lord, their Lordship Justice Ramaswamy, my Lord, though it is, my Lord, I have cited, my Lord, in my written argument. The President assent will not throw light, bloom light after the parliamentary legislation. It stops. The exact wordings, my Lord.
That legislation itself ceases to operate.
Yes.
Or voided. What is that?
Yes.
Voided or does not operate.
My Lord, it will be void, my Lord, under 254(2). 254(2). The repugnant provision, if they are there, my Lord, they are void. The President assent was there to see that, my Lord,
Not
the
voided.
repugnant provisions, my Lord, operate.
No, one finer aspect we are asking.
My Lord, if that being, my Lord, if that being, my Lord, that being the, my Lord, the law which has occupied the field, Section 96, my Lord, will apply to me also. Will be my first endeavor. Secondly, my Lord, the option available to the state legislature, either to, my Lord, re-legislate or to amend the provision so as to bring in conformity with 2013 Act.
Any decision on this aspect of the matter?
Lord, there are several, my Lord, right from the beginning, my Lord. I have
this. I'm saying two aspects. In deciding, apex court said, Shirwai, Basu, A.P. Datar, they have written that. Even Cooley on constitutional limitation, American author, in deciding in a federal system, this question is only in a federal system.
Yes, yes.
Where legislation in pith and substance relates to a subject. Apparently, in the third, in the concurrent list, this question will arise. Suppose if a law is made for urban development, and a provision in that law provides for acquisition, we can't say it's a law relating to acquisition of land. It's a law predominantly relating to the urban development, and a subsidiary of that, power to acquire land, is also given. If the law relating to acquisition of property independently is to be treated, is one thing. For example, the Hazardous Diseases Act provides for arrest and detention. An extreme example. Yes. In deciding whether the subject matter of legislation, because these are all only fields of legislation, entries, is in the state list, central list, or in the concurrent list, we are deciding on the doctrine of pith and substance.
No, that comes, my lord, only in list 3 concurrent list, only those.
No, it can happen in 1 and 2 also. Suppose in substance it is 1, but the state is making the law. There are such reported.
Yes, yes.
Therefore, it is not list 3 specific. It is all the 7 schedule specific in a wholesale way. We are not on that. In deciding whether a particular legislation is a law relating to land acquisition or law relating to industrial areas development, in this perhaps industrial areas development, that way we have to decide.
But this is the state highway, my lord.
Anyway,
yes,
we can take state highway only. The object is to form state highways, and for that, incidentally, the farmer who farms, he should have incidental powers, and those powers are to acquire land also.
Yes.
That way. Therefore, hastily we cannot jump to the conclusion that all provisions in various legislations, Gangadhar, all provisions in various legislations which provide for acquisition of land should be termed as law relating to acquisition of land for the purpose of list 3, because industrial areas development, which schedule state list.
Lord, I have given, my lord, the list. Your lordship will kindly see the amendment. Amendment, my lord, even to the schedule is made, my lord. I have given the date
in the 2013 Act.
My lord, page 2 of my synopsis, my lord, your lordship. There is a insertion, my lord, in list 3 by Constitution Amendment, my lord, dated 3/11/1977. 77 vargu irlilla.
For the construction, maintenance, and development of so
entry 42. Entry 42, my lord, of list 3 is the acquisition and requisition of property.
In a wholesale way.
How?
In a wholesale. That is the primary object.
Yes.
But if the object of a legislation is something else, and effectuation of the object requires acquisition of property,
yes,
then it does not go there at all.
Yes.
That's how the doctrine of pith and substance is developed by American courts.
Yes, yes.
And later by our courts also.
Yes.
Therefore, saying that after enactment of 2013 Act, all state legislations, to the extent they provide for acquisition, stand impliedly repealed, appear to be.
Lord, I will demonstrate, my lord, one by one, my lord.
Yes.
I will demonstrate.
Your first proposition is?
My first proposition is, my lord. My first proposition is, my lord, that Land Acquisition Act is the principal act which applies to all acquisition, my lord, in the country, because they are exercising the power of eminent domain. It's only the state can exercise the power of eminent domain.
Yes.
So it has been exercised, my lord, by, my lord, the state in legislating this, my lord, through entry 42, my lord, of list 3. Therefore, my lord, they have sought for assent of the president. My lord, one other factor, my lord, may also be noted. The president assent is prior to, my lord, the insertion of this list 3. ಅವಾಗ ಇರ್ಲಿಲ್ಲ.
Presidential assent is anterior to that particular item in the list 3 being introduced.
ಹೌದು. This is also one of the peculiar circumstances. 1964, my lord, the president assent.
At that time, that entry was not
Entry
there.
was not there.
Which entry?
42, my lord.
Entry 42.
42 of list 3, my lord.
List 3. It was there in 1956.
At the footnote, my lords will find, my lord,
Acquisition and
with
requisition
effect
of
from ಅಂತ
property.
ಹೇಳ್ತಾರೆ.
No, you
19
cannot be. It is with effect from 1/11/1956, perhaps after Bela Banerjee,
Yes.
anterior to that.
Lord, I don't know how I got this, my lord. Maybe there was some print mistake, my lord, in my book. Specifically, my lord, I remember it's 1977, my lord,
No, it
but
cannot
I
be.
find in this book, my lord,
There is already,
1956, my
there
lord.
is already a judgment I have read on that.
Yes.
You have to correct yourself.
So, yes. My lord, this 46, my lord, is the 42, my lord, is the entry, my lord, in list 3.
It is
Now, your lordship will now kindly see, my lord, section 107, my lord,
of 2013.
2013 Act.
So your first contention, which is structured that it was entry was not there, goes now.
Yes.
Go to other contention.
No, that may not be necessary, my lord. It's only, my lord, list of dates, my lord, I have mentioned, but it will not have any effect, my lord, on the.
What happens, Chandrasekhar, in India, we have no legislation which governs printing of legislations and judgments. Unlike in England,
Yes.
unlike in America,
Yes.
unlike in France, others cannot print legislations at all. They can write commentary. If they want to print legislations, they have to take permission of particular body. I do not remember that. Otherwise, what happens is, somebody would put some date there. We act upon that. We informed the publisher other day, we warned him in 2 judgments, in one judgment I warned. The other day we have written a letter to the publisher, why action should not be taken against you for printing wrong date. No was missing in that section.
Yes.
We were in fact bewildered. How can this be? It cannot, it does not run with the complete, the theme of the legislation. Then we asserted from the gadget that no was missing. One missing of no makes a havoc legislation. Yes,
107, my lord, is one of the indication that the parliament, my lord, has repealed, my lord, even the state license. An implication can be drawn. No doubt, my lord, it has repealed, my lord, the old Land Acquisition Act, my lord, specifically under 114. But this can be inferred, my lord, from 107, my lord.
how? Otherwise it would have said it in so many words.
Lord, they cannot repeal, my lord. Parliament cannot repeal the state enactment. I will develop my argument, my lord. Your lordship will kindly read, my lord. Nothing in this act shall prevent any state from enacting any law to enhance or add the entitlement enumerated under this act, which confers higher compensation than payable under this act, or make provision for rehabilitation, resettlement, which is more beneficial than providing under this act. Now kindly see the next provision also.
One second, we will scan this section. Explain this section to us.
Yes.
Section is not,
Yes.
not that simple. See that, how it is structured.
Yes.
Nothing in this act shall prevent any state from enacting any law to enhance or add to the entitlements
Yes.
enumerated under this act, which the object of this section is, it enables the state government,
Yes.
state legislatures to make law which can be more beneficial to the losers of the land.
My lord, can I put it in this way, my lord? This act, read with section 2 of this 2013 act, which says, my lord, it applies to all acquisition, where the state wants, kindly see, my lord, section 2 of the act. Applicability of this act.
Yes.
The provisions of this act relating to land acquisition.
The provisions of this act
Relating to land acquisition, compensation, rehabilitation, and settlement shall apply when the appropriate government acquires the land for its own use, hold and control, including public sector undertakings also.
and for public purpose, and shall include the following purposes, namely, so and so, so and so.
It does not restrict to, my lord, the government, my lord, of the central. It also says, my lord, the appropriate government. Means across, my lord, the central government, my lord, it applies to the state also.
Learned senior advocate Mr. S.M. Chandrasekhar submits that the 2013 Act is a comprehensive legislation and it governs the law relating to acquisition of property by any appropriate government, and therefore the provisions of law for providing acquisition in any state enactments, to the extent they are inconsistent with this, should be treated as having been repealed. Correct? No. First, in support of that, he draws attention of the court to section 2, subclause 1, clause 1, and section 107 of 2013 Act.
Interestingly, kindly see 108 also, my lord. That will again strengthen my argument. Option to affected families to avail better compensation and rehabilitation and resettlement, where a state law or a policy framed by the government of a state provide for a higher compensation than calculated under this act for the acquisition of the land, the affected person or his family or members of the family may at their option opt to avail the higher compensation and rehabilitation and resettlement under such state law or such state policy of the state. Even though the acquisition is under 2013 Act, if by virtue of section 107, if there is a state legislation, if it is more beneficial, the option is given to the land loser to say, even though you have acquired under 2013 Act, I would like to say that the compensation be paid under the state enactment, which is more beneficial to me.
Section 107 is clarificatory of state's power to legislate. Power to legislate arises not under statutes, but under the constitution.
Can I put it in another way, my lord? Even if the statute makes a law, If it is contrary to 2000 Act, lesser than the 2013 Act, you are not valid. It has to be something more than this. It's a benchmark. 2013 Act is a benchmark. Minimum that is required to be paid for land losers. It has to be something more, something better, not lesser than 2013 Act.
But that does not mean that it is a benchmark.
What says here, 107 is clarificatory. Because Parliament does not give the state power to legislate. Constitution gives the power to legislate, it clarifies. You can make law. What he says is, when such a law is made, even law need not be, if there is policy evolved by the state, even that is sufficient. Why is a policy is one thing, there can be non-law policy also, non-statutory policy, even that policy is there. Policy provides for some benefits higher than this. Option is given to the land loser to choose either this or that.
But to say further that this is a benchmark and other.
Well, even repeal argument will take it out. Suppose if this provides for that option, because see, law, various state law, there is difference between act and law. 13
Including all.
other. But even 13 is very important, unless he relates to 14, etc. But he further submits, he further draws our attention to the text of section 108, bracket nalli 108, and tells us that the provisions of section 2 read with 107 and 108 of 2013 Act prescribe the benefits to be given to land losers by way of the benchmark. First, he adds that whichever be the law, state legislation, whichever be the state legislation, inter-alia providing for acquisition, comma, its provisions relating to acquisitions would be law within the meaning of 107 and 108. Correct? Huh?
Now kindly see, my lord, 96 once again. If the contention of the revenue to be accepted, if the acquisition is only under 96, under 2013, then only the benefit of 96 will be available. Then it would be defeating, my lord, 108.
No, 108 does not provide for taxation at all.
No, my lord, what I am saying, if I opt other than 2013 Act.
No, it's compensation. Please see the section.
How's the compensation?
Let us understand the conspectus of 107 and 108.
Lord,
These are law relating to compensation, rehabilitation.
Yes.
96 is a law relating to taxation.
Lord, I am putting, my lord, in this way, my lord, if 96 is read as giving, my lord, no levy on income tax on compulsory acquisition, if it is only under 2013 Act, why should I go for state enactment? The very object of 108 is defeated. That will not be the intention of the legislature.
Let us see.
96 once again, my lord. 96 once again. What is troubling, my lords, is this act, my lord, in 96. Under this act.
Correct.
Yes. My lord, all my endeavor is to see, my lord, that I come under
This act should be read under law relating to acquisition. Because of section 2.
Yes.
107, 108, your submission.
Yes.
But under this act, that amounts to the court manhandling the provisions of parliamentary legislation. Exemption is exemption heading wrong. It's not exemption at all.
No income tax or a stamp duty shall be levied.
Not exemption. The headline.
Lord, thou ಹೇಳಿದ್ರಿ headline also plays a role. Lord, I have few judgment picked up few
In
judgment.
India, yes.
Lord,
provided it does not offend the substantive provision.
I have cited, my lord, in my notes. My lord, it has to be, my lord, substance of the section, not the head note.
Not the head note at all.
Not the head note at all.
Therefore, it is not a case of exemption.
It is the case of non-levy. Non-levy.
That's how.
Yes.
That's how Palkiwala treats.
Yes.
In his Kanga in Palkiwala, in income tax. Levy of tax is one thing. Exemption
is another
tax
thing.
is another.
Yes.
In fact, that question arose in the case of Mother Teresa, who got Nobel Prize. The question arose before the income tax department, whether the income, it should be treated as income or not. If it is treated as income, then tax has to be paid. Then Palkiwala gave an opinion, which Palkiwala's biographer, M.V. Kamath, Palkiwala the man, in that one, whole chapter is dedicated to that. Palkiwala gave an opinion saying that the levy of tax is one thing, exemption is another. Unless there is leviability, case will not travel to exemption at all. This is how we are structured. In one judgment, we have quoted that also.
Article 265 also, my lord. There has to be a law providing
for
levy. If there is no provision enabling to levy tax, then the question of, my lord, exemption or anything else, my lord, will not arise.
In that, the government of India accepted legal opinion of Palkiwala.
Yes.
The question is that therefore we need not be governed by what the heading of the section governs rules. Yes. Question is, no income tax shall be levied. Therefore, it goes to root of the matter, levy of income tax. This we call Justice Venkatachalaya, the great judge of Union, the Chief Justice of India, called such a legislation as ragbag legislation, where legislation is relatable to one single entry, in list 1, list 2 or list 3. We are fully aware of those things. Where a legislation is relatable to multiple entries in the list, he called it for the first time as ragbag legislations because multiple entries are involved. Here, this is a section 9. This is a ragbag legislation only in the light of Ujigar Prince versus so and so, so and so. Ujigar Prince, Gangadhar. Take out that judgment, one paragraph. That will be relevant. We'll come to that one. In our constitution, there is no prescription saying that where you make a legislation, it should be compulsorily relatable to one entry only. There can be multiple entries, and the legislature in its wisdom can evolve legislative policy that may touch multiple entries. It is one such legislation. Why we are saying this is, law relating to income tax need not be in the income tax fully. There can be law relating to income tax in other legislations also. One such example is section 97.
Lord, I am dealing with that, my lord, when I come to, my lord, 194 AL. Now, my lord, I confine myself to, my lord.
Understood. We have understood. We have understood. We have understood. In fact, kindly come to 107, 108 again.
Yes.
Nothing in this act shall prevent any state from enacting any law to enhance or add to the entitlements enumerated under this act. What are the entitlements?
Lord,
Entitlement to exemption from tax also can be.
it can be one of the aspects, my lord. It talks of all the components, my lord, of
Other compensation than payable. See, 107 and 108, my brother and we are, me, they relate to, they are compensation specific, to borrow his words. They are not, they are purely compensation specific, rehabilitation also, perhaps the resettlement, rehabilitation, 108. But they have nothing to do. They keep miles away from the law enacted in 96. Appears to be that. We want to have more light from your side.
My endeavor was to show, my lord, if the option under 108 is provided, my lord, to the land loser, if he goes and says state legislation I am going to, my lord, opt for, the benefit of 96 will be deprived of.
Correct.
The legislature, my lord, will not, the legislature will not, my lord, create a situation.
Read 108. Read,
Yes,
please read
yes.
108.
Where a state law or a policy framed by the government of a state provides for higher compensation than calculated under this act for the acquisition of the land, the affected person or his family or members of the family may at their option opt to avail such higher compensation and rehabilitation and resettlement under such state law or such policy of the state.
Where does it relate to taxation?
My lord, what I am trying to say, my lord, if the option is given to me, it is not with an intention to defeat 96. It should go along with 108 also. If I am opting for state legislations, my lord, the compensation. Otherwise, my lord, I will be deprived of 96 benefit of non-levy of tax. If it is to be construed narrowly.
Our question now. Taxation is not within the contemplation of either 107 or 108.
Therefore, my lord, my respectful submission is, my lord, 96 applies to across, my lord, for all persons, whether it is acquired under the State Act or under the 2013 Act. It shall not make any distinction.
Notwithstanding,
yes,
the phrase employed in 96,
yes,
acquisition done under this act.
yes. My ultimate analysis, my lord, will be in that direction. The parliament will not legislate. The parliament will not legislate any law, my lord, making a discrimination among the class of a person if they form, my lord, one class.
They form different class ಅಂತ parliament ಹೇಳೋದು.
ಅದಕ್ಕೆ ಹೇಳಿದ 2013 is the principal act. One class of a person is the land losers.
Not 708 purchases. That also will apply. Under this act, we lose significance. Under this act, 24 is 24. ನೋಡಿ ಅಲ್ಲಿ LC Goyal on words and phrases. Merci. This act. Yes, sir. Good. Can you go to next point?
Please. My Lord, I have given certain judgments, my Lord, on the, kindly see, my Lord, 254, my Lord, my Lords must have seen several times, my Lord.
Well, see that.
254.
No res judicata for reading. Most of these provisions are by heart to me. Yes.
Lord, I'll be, my Lord, interested in reading only the provision, my Lord. Rest of the things, my Lords are aware. Provided nothing in this clause shall prevent a Parliament from enacting any time any law with respect to the same matter, including a law adding, amending, varying, or repealing the law so made by the legislature of a state.
Correct. Even despite granting assent.
Yes.
Post assent it is.
How?
Suppose you have given assent, therefore you cannot make law. You cannot say that.
Yes.
To clarify that, they have borrowed it from American Constitution.
What is the effect of that law which
That
has
will
made
go.
earlier?
That will
Lord,
go.
that is precisely, my Lord, my.
Provided such a law is made.
Yes.
Whether such a law is made is the question.
2013 Act is the.
Therefore, question is, there is not just 2013 Act. Section 96, though is found in the body of 2013 Act, it is a law relating to income tax.
Lord, I will deal with that.
There is difference.
In income tax component, my Lord, I will.
I want to clarify these things.
Yes.
I have made lot of works on this. Very with humility, I say.
Yes.
Unless we understand the sources of law, which Salmon Jolovich, they say, they generally classify these sources into 5 heads. One is legislation, second one is custom, third one is precedent, fourth one is contract, fifth one is opinio juris, jurist's opinion, which open him in international law, J.G. Stark, etc. They say in international law, the opinions of tall jurists is source of law. That may not be much here. There's one section which says section 42 or 43 of our Evidence Act also. That's another thing. Coming to first source for clarification, because it will help us,
yes,
if not you.
Yes.
Legislation is not law.
It's only a
source of law.
To make a law.
Source of law. Legislation, someone says, is a process by the conventional legislative body, in exercise of which law comes into force. Law takes birth. This is how summoned jurisprudence, well, especially 12th edition, Fitzgerald's edition. More than that, the 9th edition is there by Glanville Williams. He has given it more elaborately. Anyway, therefore, unless this clarity we have, we will not be in a position to construe 96, section 2, 1, 106, 7, 8, 9. Therefore, what we are saying is, the law, section 96, providing not exemption, providing non-levy of income tax for the lands acquired under 2013 Act is a piece of law relating to taxation. It is income tax, not even other tax. Only acquisitions done under 2013 Act, the Parliament says the compensation is not accessible to levy of tax. We are just asking you, if they wanted to depart or expand the contours of 96, they would have structured 107 and 108 that way. They would have said, even non-levy of tax benefit, they would have covered. They are very specific. Compensation, rehabilitation, resettlement. Only 3 things.
Lord, I have drawn the attention of the court 107, 108 to drive home the point that, my lord, the State Act is impliedly repealed. Therefore, the only law that is available for the state to acquire the land exercising the power of eminent domain flows from section 2 of 2013 Act. They could have acquired the land only under this act, and that is the only law.
According to you, BDA Act will die,
All acts will die.
ADB Act will die,
All acts will die.
all state legislation.
All state, Lord, then the question would be,
That will be chaotic.
Lord,
Accepting your contention will be chaotic.
my lord, this is the legal consequence, my lord, of 254. Then, my lord, you will go to the next question, my lord, the doctrine of pith and substance. Whether the act which has been re-legislated by the parliament, which is the provision independently, without going into the question of the validity of the precedent assent, my lord, given to the state enactment, without going into that question, the question would be, my lord, pith and substance of that particular provision, whether it is repugnant to the parliamentary legislation which was reenacted.
Please take us to repealing provision of the 2013 Act.
My lord, 114, my lords.
What are repealed?
Only one act, my lord, state, my lord, they could not have repealed, my lord. Therefore, I am saying, my lord, implied repeal of the provision having regard to, my lord, 254. Then we'll have to undertake the exercise of pith and substance repugnancy provisions, my lord, to the 2013 Act.
The same question arose before the Supreme Court. When the Limitation Act 1963 was enacted,
yes,
there is repeal section. It repeals 1908 Act. The Supreme Court, take out, Mr. Gangadhar, take out that judgment. Limitation Act 1963 alone is repealed. Ujjwal, the rag bag, where is that, that rag bag there? That's there, I have read, I remember having read that judgment during my initial days.
My lord, I have, my lord, given the citation of Javeri Bhai, Barari.
Javeri Bhai.
Yes, Javeri Bhai. All this, my lord, I would like to impress upon this court, my lord, to see the judgment, my lord, rendered in Vijay Kumar Sharma's case.
Vijay Kumar Sharma's case.
Which I was relating to, my lord, the motor vehicles.
For a moment, can we adhere to the repealing provision of the legislation?
114, my lord.
114. It repeals only 1894 Act.
How?
If they wanted, if the parliament intended to repeal various legislations in the state, it would have enlisted under 114 only.
Lord, may lord kindly see, my lord, 104, my lord.
104.
105, my lord.
In fact, 103 contravenes, runs counter to your argument. Provisions to be in addition to existing laws.
How?
The provisions of this
Lord, this provision, my lord, is all
and not in derogation of any other law for the time being enforced. If
Lord,
they intended to.
ಅದು ಎಲ್ಲ ಆಕ್ಟ್ ಅಲ್ಲೂ ಹೇಳ್ತಾರೆ, ಅದು ಯಾಕೆ ಹೇಳ್ತಾರೋ ಗೊತ್ತಿಲ್ಲ. ಎಲ್ಲ ಆಕ್ಟ್ ಅಲ್ಲೂ ಹೇಳಿ ಕೋರ್ಟಿಗೆ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡಿಡೋದು. ಎರಡೂ ಅಲ್ಟಿಮೇಟ್ಲಿ ದ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಸೇ ಬೋತ್ ವಿಲ್ ಪ್ರಿವೇಲ್. Now kindly see, my lord, they have given the list of the, my lord, the provisions which.
Kindly come to 105.
Yes, my lord. Subject to subsection 3, the provisions of this act shall not apply to the enactment relating to the land acquisition specified in the fourth schedule.
Let us go to fourth schedule.
My lord, all these four schedule cases, my lord, the land acquisition matters are all relating to central legislation.
Maybe that how can Parliament kill the legislations made by the state in respect of part 2?
ಅದಕ್ಕೆ deemed repeal ಅನ್ನೋದು.
Part 2 ದಲ್ಲಿ ಹೆಂಗ್ ರಿಪೀಲ್ ಮಾಡೋದು? Part 2 legislation is
part 2 ಅಲ್ಲ, part 2 ಅಲ್ಲ ನಾನು ಹೇಳೋದು. ಇದು this also all these legislation relating to land acquisition only.
ಹಂಗನ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ. ಆ ರೀತಿ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅನ್ನೋದು ನಮ್ಮ ವ್ಯೂ. ಯಾಕೆ ಹೇಳ್ತೇವೆ ಅಂದ್ರೆ there is some logic in that. There are various items in state list.
Yes.
In respect of which legislations are made. They provide for acquisition. Those are not the law relating to acquisition. They are the law relating to the dominant field of legislation. KIDB Act.
ಇನ್ನ ಮುಂದೆ ತಾವು ಓದಿ ಯಾವ್ದು 105 ಅದು ಅಲ್ಲಿಗೆ ಮುಗ್ದಿಲ್ಲ.
Subject.
Next with the rider.
Yes.
This clause 3, my lord. Subject to subsection 2 of section 106, the central government may by notification omit or add to any of the enactments specified in 4th schedule.
Because there was central legislation.
Yes, yes. My lord, this central government shall by a notification, kindly mark this, my lord, within 1 year from the date of commencement of this act, direct that any of the provisions of this act relating to the determination of the compensation in accordance with the 1st schedule and the rehabilitation and resettlement specified in the 2nd and 3rd schedule being beneficial to the affected families shall apply to the cases of land acquisition under the enactment specified in the 4th schedule and shall apply with such exception or modification that do not reduce, kindly mark this, my lord.
Correct.
That do not reduce the compensation or dilute the provisions of this act relating to compensation, rehabilitation, resettlement as specified.
Correct.
Yeah.
But where is the subject congruity, the contiguity of subject of taxation?
My lord, I will deal with that 96, my lord, later, my lord. I am now only dealing with an aspect of repeal of the provisions of the state enactment. What is the law that is occupying the field, and which has, my submission would be, my lord, the entire field of acquisition is acquired under 2013 Act, my lord, after coming into the force of this Act. And they are deemed to have been repealed.
Then Shaker submits that all provisions of all state legislations that provide for acquisition of land would stand impliedly repealed by virtue of 2013 Act, which has to be treated as occupying the field of legislation.
2013 Act.
30. That many legislations, fields of list to the other new legislation, compulsory acquisition of provide that legislation. No, this doctrine of occupied field will apply only to the current doctrine of occupied field. Doctrine of occupied field is confined to list 3. List 3. If legislations are made in respect of list 2, and KIDB Act is one such, the assent of the president might have taken by abundant caution also, it is permissible.
If I am permitted to say, my lord, those provisions, they not only fall under 42 of list 3. Incidentally, they fall, my lord, under the another entry, my lord, of either list 2 or list 1 or even list 3, development of industry. Therefore, my lord, the courts would be holding that it is occupying a different field and it is a special enactment. Therefore, it is a my lord, it is a self code. Therefore, they are not repealed. Is the line of argument, my lord, in those cases, and the courts have consistently held if they are falling under any other entry. Industrial development, my lord, is another entry. Urban development, my lord, is another entry. Housing development, my lord, is another entry.
Yes.
Therefore, my lord, first the court will make an endeavor to see that no enactment is declared as impliedly repealed. As much as possible, it should be seen that both exist, both operate. Wherever it is possible to hold that a particular section is repugnant to a particular entry, a particular section in the principal act, to that extent, the courts are holding that they are repugnant and void, hit by Article 254(2). Yes. But my all this endeavor to see that 96 also applies to all.
Of course, that's what. That's what.
I can say it now. I can say it only when I say that all other enactments have gone. This is the only field occupied, and this is the only law that is applicable for acquisition of the land. That will be my endeavor.
Therefore, 96 benefit has to be out.
Yes.
Any other proposition? We have understood this now.
My lord, one judgment, my lord, of this my lords will not find in any other judgments, my lord.
For the proposition?
Allah, on the question of president's action.
The Talach is there, na? Talach versus so and so. Covers your proposition.
ಇದು ಒಂದೇ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೇ ತರ ಹೇಳಿದ್ದು ಬೇರೆ ಯಾವ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲೂ ಹೇಳಿಲ್ಲ. Though it is minority judgment. My lord, kindly see, my lord, page 18 of my written.
No, why are you making that overstatement?
Maybe, my lord, ಅದು ಒಂದೇ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದಾರೆ. ನಾ ಬಹಳ ಹುಡುಕಿದ್ದೀನಿ, ಎಲ್ಲೂ ಸಿಕ್ಕಿಲ್ಲ. The assent of, what is the effect of the assent of the president given earlier?
That is
what would happen to the assent of the president taken earlier to a state legislation?
No, that everything goes. Once center legislate, power to legislate is a very special power given by the constitution, where legislation is made in respect of an item in the concurrent list by the state with the assent of the president, because there is already a legislation in occupying the field. That does not rob the parliament of its legislative power to enact. Once it enacts, even in respect of assent given, that assent given will go.
Absolutely right, my lord. I only want to write 4 lines, my lord. Page 14, my lord. Para 18, my lord. I'm sorry, my lord. Page 18 of my written, sir.
In fact, Sirvai writes on that in 4th edition. Your
the assent, may I read, my lord? 4 line ಇದೆ. 18, page 18 of the written submission. ಬರ್ದಿಲ್ವಾ?
Submissions ಅಲ್ಲ ಸರ್?
ಹೌದು.
Synopsis.
I'm sorry, my lord.
ಎಲ್ಲಿ ಒಂದು
Paragraph 36, my lord. 36 ಆದ್ಮೇಲೆ. 36 ಆದ್ಮೇಲೆ 2 pages.
36 Vijay Kumar Sharma.
Vijay Kumar Sharma. My lord, at the bottom of the next page, my lord. Vijay Kumar Sharma.
36. It is submitted.
ನಾನು bold letter ಅಲ್ಲಿ ಮಾಡಿದ್ದೇನೆ.
Correct.
The assent of the President of India under Article 254(2) given to the state law. Karunanidhi ಅದಲ್ಲ.
Para 36.
Vijay Kumar Sharma.
ಅದು ನೀವು para 36.
I'm sorry. Karunanidhi judgment ಅದರಲ್ಲಿ extract ಮಾಡಿದ್ದಾರೆ.
That's what.
Yes. Yes, my lord. Now, next page ಅಲ್ಲಿ. Majority judgment have, my lord, followed the Karnanidhi's case.
The assent of the president.
Yes, assent of the president under Article 254(2) given to a state law, provisions therein accord only to operational validity through the repugnant to the central law, but subsequent law made by the parliament or amend, modification, variation or repeal by any act of the parliament render the state law void. The previous assent of the president does not blow life into the valid law. This is what I would like to emphasize, my lord.
In support of his submission, he banks upon the Apex Court decision in Karunanidhi, para 88, Roman 11, which says that once assent is given to the state law, comma, the power of the parliament to legislate is not taken away. And once the parliament enacts law, comma, the state law would commit legal suicide. And subsequent grant of assent thereto would not revive it. Just a if you want to do what he says is, that's right also.
Not close the light.
That because it is a dead horse cannot be revived on earth. That is there. So subsequent grant of assent would not give life, infuse life into the dead law. Easy. But that question, how that will arise now?
State
2013 Act is subsequent legislation.
How though? Now what should happen to the state legislation? That is State Highways Act.
According to you, that at least part of that legislation will die.
How? What remains is the power of eminent to be exercised only under 2013 Act. Now the next question would be, my lord, what is the option available to the state legislature in the event of, my lord, parliamentary power being exercised in the same occupied field?
It can make law and obtains assent again.
My lord, that is what, my lord, I have said. In exercise of that power, my lord, state government have issued a notification under, my lord, the notification on 14/11/2014.
State has issued that.
State has issued a notification.
Who has issued that?
My lord, by the order in the name of the governor, my lord, we have produced the copy of it, my lord.
It's relatable to?
Relative to, my lord, the manner of computing, my lord, the compensation in tune with the 2013 Act. 2013 Act, my lord, sum and substances, 2013 Act, my lord, has been adopted.
It's only computation of compensation.
Only this is related to two of the projects where World Bank has funded or something like that.
How?
Not other.
For the entire-
This is not world.
Namaga apply agittidu. Namaga apply. It applies to us, my lord.
So we will read that order, sir. It is a better.
Yes.
Last paragraph of the
Yes.
order.
This,
In superstition of the government.
no, it is better from second paragraph.
Yes,
onwards of
the government of India has brought into force the new act, the right to fair compensation and transparency in the land acquisition, rehabilitation, resettlement, 2013, with effect from 1/1/2014. Section 103 of the act provide that it shall be in addition to and not in derogation of any other law for the time being in force. That section 107 provides that the act shall prevent any state from enacting any law to enhance, not prevent any state from enacting any law to enhance or add to the entitlement enumerated under the said act, which confers higher compensation than the payable, and made provisions for R&R which are more beneficial than the benefit under the 2013 Act. Since LA process are at the advanced stage, it is decided to continue the process under the Karnataka Highways Act 1964 by suitably amending the policy framework and entitlement matrix, ensuring that the compensation and rehabilitation resettlement assistance are equal to or higher than the quantum prescribed in 2013 Act. Accordingly, the revision of land acquisition, so and so principles and policy framework, entitled matrix was provided in the project governing board in its meeting held on so and so. The board provided the proposal, the subject to extend the provisions of annuity, lump sum, etc., only to those who lose 1 hectare of dry land and half an hectare of wetland, to those title holders and to those entitled commercial structure of more than 50 square meters, and that the revised land acquisition and rehabilitation policy framework, including the entitlement matrix, is applicable to World Bank and Asian
funded work.
including, my lord, kindly see, my lord, framework including the entitlement matrix is applicable to World Bank and Asian Development Bank funded work being executed by, yes, KRDC. Accordingly, the chief project officer wants to.
KDP ಅಲ್ಲೆಲ್ಲ. Highways.
Only
Highways
the
Act ಗೆ ಅಲ್ಲೆಲ್ಲ.
particular project is funded either by the World Bank and the
Lord, this,
Asian Bank Development
Lord, my
Bank.
instructions are, my lord, this is funded by the World Bank.
No, ಹಂಗ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಮೇಲೆ ಹೋಗ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಎಲ್ಲರ ಪ್ಲೀಡಿಂಗ್ ಬೇಕು. It's a very serious issue. Can we go in those matters by instructions?
That may be
Where
true.
have stayed?
See again, sir, why I am saying, because the second paragraph says some project was brought in the board and board has taken conscious decision to see that projects are immediately implemented.
Yes.
Because it is funded by the World Bank.
Yes.
There is object this a kind of mechanism. It is not that the honorable governor has brought in some amendment law into this and
Number
made
one.
applicable.
Now kindly see, my lord.
We'll assume that it applies now.
Yes.
We'll go one step further.
Yes.
We'll assume against ourselves that this policy is invocable in your case. Where does it whisper one single word about taxation?
My lord, kindly see, my lord, page 7 in that.
Page 7.
How? It is stated in a different way, my lord.
This GO is relatable to which provision of the Constitution? Which provision of the legislation?
My lord, this is relatable to, my lord, executive order,
Power of the state.
executive power of the state.
Can the state in exercise of executive power rob away the power of the parliament to levy income tax or to grant non-levy benefit by where the federal principle will go? The principle of federalism is one of the basic features of the Constitution. Says Keswananda, Indira Nehru, Gandhi, so many judgments. What will happen to federal structure if we argue this, if we accept your contention?
They are only adopting the provisions of, my lord, 2013 Act. Whatever the benefit that has been given under 2000 Act are made applicable to the land losers, my lord, in the state project.
How?
By making, my lord, the
Power. That if we accept yours, what all amount would go to the consolidated fund of the country, India, will be halted by executive instruction. The 107, the 96 excludes acquisitions done under 2013 Act from putting something in the coffers of the central government. If this is to be read as such, in all cases of acquisition which fall outside the 96, even that money will not go to the coffer of the central government. That will be horrible. That will be disastrous for the federal economic structure.
even the central government, my lord, have issued a similar notification in respect of those matters which your lordships have seen in Schedule 4.
Correct, because power is there.
Schedule 4 ಅಲ್ಲಿ. Schedule 4 enactment, which
Chandrasekhar, under our constitutional setup, budget is at the hands of the
I can
executive.
only put it in this way, my lord. It may not be strictly an amendment of State Highways Act, but it is, my lord, a device adopted by the state, my lord, in the interregnum. When finally, my lord, the amendment process will take.
Mr. Chandrasekhar submits that the state government has evolved a policy through notification dated so and so, extending all benefits otherwise available to the land losers for acquisition, as would be availing to the owners of the land losers under the acquisition, in acquisition under 2013 Act. 13 Act. Concomitantly, the benefit contemplated under section 96 of the 2013 Act would avail to the land losers under the state legislations also.
My lord, hangilla, my lord, I think, my lord, we'll have to see this, my lord. It's in a different language, my lord, not the way in which it has been stated in 96. Your lordship will kindly see page 7. State government nare ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ income tax.
ಅವರೊತ್ತಿಗೆ ಇಸ್ಕೊಳ್ರಿ. How can?
ಆ ಥರ ಹೇಳಿದಾರೆ. Lord, we are at the receiving end, my lord, whatever.
Not like that, not like that. Just to get more light from you.
Page 7, my lord. Page 7, my lord, of this. Notification. Tabular column ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದನ್ನ remarks at the end of it, my lord. All taxes, my lords, have this, my lord.
Including income tax, if any, will be borne by so and so, so and so. Go
How?
and tell them.
ನಮಗೆ ಇವರು
You have said like this, you give all that. You go and tell them.
ನನಗೆ ರಿಫಂಡ್ ಮಾಡ್ಬೇಕು ಅವ್ರ ಹತ್ರ ನಿಸ್ಕೊಳ್ರಿ ಅಂತ ನಾನು ಹೇಳ್ದೆ. ನನ್ನ ಹತ್ರ ತಗೊಂಡಿದ್ರಲ್ಲ.
It says state you should make and get it reimbursed. See the language, all taxes including income tax if any will be borne by so and so. So
Now the, my lord, the land acquisition officer has deducted and given it to income tax officer.
prosecuting. How can we, this may be enforceable also, we do not know, because of that Felix Frankfurter's judgment. Justice Felix Frankfurter of US Supreme Court said, where you tell something to your citizens, which is beneficial to them and detrimental to the government, you are bound by your assurances to the citizen. That judgment is referred to by the apex court in two judgments. One is B.S. Minas versus Institute of Statistical Sciences, which that great lawyer who died of the bearer bond case. Bearer bond case. He died in road accident. Garg had. The another is R.D. Shetty's case. In both these judgments, they have very copiously referred to Felix Frankfurter's judgment. You can make use of that. But how can you say that the amount shall not, it only says you have to pay the tax, but we will reimburse you. Nothing beyond that. Because tax is, suppose if the tax were to be paid to the state government, like agricultural income tax, we'd have understood. The money which should go to the central's coffer, that cannot be halted by our legislative judgments. Subject to what we are only talking, because we are attacking him. There is the attack waiting for you. That's another thing.
If I sustain my first argument, my lord, the principal piece of legislation to acquire the land is 2013 Act. State cannot acquire any land.
All because assent was obtained to that act, even all those acts will go. This will take, this appears to be the
Yes. Now, my lord.
No, independently, we say, because of that.
Lord,
That we can understand.
My lord, there is one other aspect to be taken into consideration, my lord. The challenge to section 28 of the State Highways Act, my lord, was filed before the section 28, my lord, was a subject matter of challenge, my lord, before the Honorable Supreme Court. In that matter, my lord, the state has filed an undertaking, my lord, an affidavit that the compensation will be paid. Lord, page 61, my lord, of the compilation, my lord, filed on 27/8/2024.
Saying
undertaking is given before the Honorable Supreme Court that we will pay compensation in terms of 2013 Act.
Correct. They should pay, they will pay.
The validity of 28 was called in question.
That's all right.
Yes.
Now, how that's going to advance your case?
Lord, the state is
said, whether the state did it say the 96 would be
tax ಯಾರ ತಲೆಯಲ್ಲೂ ಇಲ್ಲ, ಅದು ಬಂದಿರೋದೇ
adhocism ನಿಂದ ಹೋಗಿಬಿಟ್ಟಾರೆ. What he says, because you can't, parliament is never before the courts. What government will say, parliament is not bound by it. That Minerva Mills. No.
Say that exemption.
Paragraph 7 of the judgment, my lord, of the honorable Supreme Court.
It's all matter touching economic federalism, financial federalism, which Ivor Jennings, great thinker, has treated. Yes.
Lord, it has been said like this, my lord. In this regard, we take note of the affidavit. My lord, page 69, my lord, of this compilation, my lord, filed on 27/8.
60.
Court of Surrey, these are-
Twenty-four nine. ಅಲ್ಲ 24/9. 27/8. ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದದು?
27/8/2024. Along with some judgments, my lord, list of authorities.
Running page number?
68, my lord.
68. Further issue has been raised.
A further issue has been raised before us with regard to the validity of section 28 of the State Act, which contemplates grant of compensation in accordance with or having regard to the provisions of section 23 and 24 of the Land Acquisition Act. It is contended that the quantum of compensation contemplated in the State Act is inadequate and no additional compensation or solution is provided for under the State Act. Though the said issue was not raised before the High Court, yet in view of the significance thereof, we have heard the parties on the said issue. In this regard, we have taken note of the affidavit and written submission filed on behalf of the state of Karnataka, dated 15th November 2016, wherein it has been categorically stated that the compensation for acquisition of the
Paid
land.
under 2013 Act. That's what we have read that. That's all.
Will on par with the provisions of erstwhile Land Acquisition Act and the right.
We have no issue as to compensation at all. We are on the leviability of income tax. We are not on compensation at all. Absolutely not. We are miles away from concept of compensation. You were section 2 subsection 1 read with 789 would be the trump card of your case. The rest of the things are frill to the frock. Of course, frills also have a role to play in giving beauty to
My
the frock.
only endeavor was to say that the state has taken a corrective measure
to the central law.
To the central law.
Can state sit in appeal over what center does? In our federal structure, Dr. Ambedkar has said, ours is, he only quoted what Professor Casey Ware said after studying Indian constitutional law. Indian constitution is quasi-federal in nature. Dr. Ambedkar said it is more quasi-federal in nature than Professor Casey Ware has said. So that we have to keep in our mind. Means most of the provision, unlike in American constitutional law, the residuary legislative powers are vested in the parliament, unlike in American constitution where it is vested in the state legislatures. So can the state say, we will amend central law, except where it fits into the 252, 3, 4, etc.
I may
That has not happened.
Lord, I may also bring to my lord's notice, my lord, similar statutes were there, my lord, in Tamil Nadu state. And Tamil Nadu, there was a challenge, my lord, to all those enactments. And the Madras High Court have declared that they have become, my lord, impliedly repealed. And the matter went to Supreme Court, and the matter is pending before the Supreme Court. Identical legislation, my lord, of all states, my lord, which are my lord, the matter is now pending before the Supreme Court. When the matter was pending before the Honorable Supreme Court, they make some amendment, my lord, to all those state enactment. Without disclosing, my lord, the repugnancy and all that, they obtained the President assent, revalidating their state enactment. And again, it becomes a subject matter of challenge, my lord, before the
Because
Madras.
of the proviso to 254.
Oh. As required under 254, my lord, they get revalidated. And it becomes a subject matter of a challenge, my lord, before the Madras High Court. And again, it rejects, my lord, the matter went to Supreme Court. Supreme Court, my lord, taking into consideration, my lord, the mechanism of 254, rightly or wrongly, President has given assent. It is revalidated.
Contrary to Karunanidhi.
Yes, it is revalidated. Therefore, it is a law, even though it is repugnant to 2013 Act, that is the law that is applicable. And ultimately, my lord, the first matter which was there pending, it is rejected. You are permitted to urge all your grounds in that case. The inadequacy of granting compensation with reference to 2013 Act and the state 13
Did
Act.
they relate to levy of income tax? Because that Madras judgment, one judgment written by Justice Chandru, I read that judgment. It does not refer, which judgment you are referring to, I do not know.
Lord, the entire
There were a set of
96 irle illa adralli. 96 was not
Ille,
there.
that's
It
what.
was not there. The validity of those act. Similarly, my lord, there was a challenge, my lord, to the KDB Act, my lord, calling it, my lord, it has become impliedly repeat. Lord, I argued that matter, my lord, and my contention, my lord, was not accepted, and the matter is pending before the Supreme Court.
We hope that your contention is accepted.
Lord, with regard to 96, my lord, I will elaborate, my lord, with reference to the Income Tax Act, my lord. Please.
Help.
I have extracted, my lord, the income tax provisions, my lord, in my written argument.
They go, you other day you argued more on exemption.
Yes, my lord.
We are not on exemption.
I'm not.
Heavy ability.
Yes. Lord, if my lords were to see, my lord, 194 LA of Income Tax Act. Written argument. I would like to emphasize, my lord, on the aspect of section 2, section 47, your lordship.
Section 47.
247. 247.
Every kodi, andre easily siktade. Income tax literature is more cosmic in size. Very difficult to find out where law lies. 246.
246, my lord. Lord, if my lords were to take, my lord, my written
46,
argument. Now, written argument I'll extract madidini instead of searching.
We'll see the case. 246.
47.
47.
Adralli I.
247 repeal agide.
47.
247.
Section 2, subclause 47.
Section 2.
Subclause 47.
You ನೀವೇ ಸಹಾಯ ಮಾಡಬೇಕು ಇದಕ್ಕೆ ಕೊಡಿ.
Lord, I have extracted, my lord, in my written argument.
Page number.
Page 30, your lordship.
1.38. 1.38.
Page number 30 ಇಲ್ಲ.
1.38.
ಇಲ್ಲ ಹೇಳ್. The effect of section 96 ಅಂತ.
ಯಾವ dated?
Para 54.
Dated ನಿಮ್ಮ.
Dated, my lord, 24/9, my lord.
27/8.
The effect of 97 ಅಂತ heading ಇದೆ. Para 54.
Brief synopsis of the proposition of law.
ಹೌದು, ಅದೇ ಅದರಲ್ಲೇನೆ ಪ್ಯಾರಾಗ್ರಾಫ್ 43 ಆದ್ಮೇಲೆ 53.
24 September. Paragraph?
Paragraph 53 ಆದ್ಮೇಲೆ headline, effect of 96.
Yes.
We will paginate, my lord. ಆಯ್ತು. Definition of transfer ನಲ್ಲಿ the compulsory acquisition thereof under any law, my lord. Kindly mark that, my lord.
Compulsory acquisition thereof under
Any law.
So acquisition includes, transfer includes acquisition.
Acquisition.
Compulsory.
Made under any law.
Correct.
Lord, what I would be emphasizing, my lord, is the legislatures have created one class of person who are liable to pay tax on acquisition of the land if it is done under any law, is one class of person.
Yes.
Now kindly see, my lord, in the same section 10 nalli subclause 3, any transfer by way of compulsory acquisition, again under any law or a transfer the consideration of which is determined or approved by the central government or the Reserve Bank of India. Again there is any law.
Compensation is approved by the central government. Approval ಇದೆ ಅಲ್ಲ, ನಮ್ಮಲ್ಲಿ ಸ್ಟೇಟ್
ಅದಕ್ಕೆಲ್ಲ-
ಗವರ್ಮೆಂಟ್ ಅವಾರ್ಡ್ ಬರ್ತಲ್ಲ ಆ ರೀತಿ.
ಆ ರೀತಿ.
ಇದು ಸೆಂಟ್ರಲ್
Lord, it's only incomes not included in the total income. Our notification on ಕೊಡ್ತಾರೆ.
ಇರ್ಲಿ.
I am only emphasizing, my lord, the word, my lord,
Any law.
any law, acquisition under any law.
Where award is approved by the central government.
ಆತರ ಇಲ್ಲ. 194 ಎಲ್ಲೆಲ್ಲಿ ಹೋದ್ರೆ ಆತರಲ್ಲಿ ಬರಲ್ಲ. Then I have extracted, my lord, a capital gain. ಅಲ್ಲಿನೂ ಎನಿ ಲಾ ಅಂತ ಬರುತ್ತೆ. ಹೆಡ್ಲೈನ್ ಹಾಕಿನ್, my lord.
Kindly come to 3.
3.
Roman 3. 47 defines transfer.
Yes.
ನೀವು ಆ ತರ ಎಲ್ಲೂ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಇದು ಆನ್ಸರ್. Roman 3.
Such transfer is by way of compulsory acquisition under any law, or a transfer of consideration for which is determined or approved by the central government or the Reserve
Bank of India. ಇದೆ.
Capital gain again, my lord, section deals with
ಒಂದು ಏನ್ ಹೇಳ್ಬೋದು ನೀವು ಅಂದ್ರೆ ಎನಿ ಲಾ ಕಾಮ ಇದೆ, ಕಾಮ ಆದ್ಮೇಲೆ ಆರ್ ಬರ್ತದೆ, ಅದಕ್ಕೆ ಮಾತ್ರ ಇದು. So all acquisitions under any law will be covered.
Yes. One class, I want to say, my lord, one class of persons.
Yes.
Now kindly see, my lord, after 2 pages, my lord, 194 LA, my lord, we have extracted. Any person responsible for paying to a resident any sum, being in the nature of compensation or enhanced compensation or the consideration or the enhanced consideration on account of compulsory acquisition under any law for the time being in force, any immovable property. Kindly see, my lord, other than the agriculture illa.
Agriculture, because agriculture income tax is under state law.
ಅದಕ್ಕೆ ಅದನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ದಾರೆ. And shall at the time of payment of such sum in cash or issue of check or a draft or by any other mode, whichever is earlier, deduct an amount equal to 10% of such sum as an income tax thereon.
TDS. How that's going to assist you?
My lord, this is the charging section, my lord.
No.
My lord, this is where they say, my lord, tax is leviable. 194 LA.
It is not a charging section. There are such judgments. It is only deduction of tax at source.
Yes.
He deducts so much amount.
Yes.
That is not a charging section at all.
My lord, capital gain el bantal 45.
Charging section is elsewhere. We will come to that one.
Yes.
This only imposes an obligation person who is making payment.
Yes.
Prima facie, he should deduct so much amount. then charging is taking care of this. This is a deduction at source.
Yes. And thereafter, my lord, one circular is issued, my lord.
Yes.
36. Circular number 36, my lord, we have extracted that just above paragraph 58. Taking note of 96, my lord.
Yes.
Relevant extract, my lord, we have produced the circular also. As no distinction has been made between the compensation received and compensation, compulsory acquisition of agriculture land and non-agriculture land in the matter providing exemption from income tax under so and so act. The exemption provided under section 96 of so and so act is wider in scope than the tax exemption provided under the existing provisions of IT Act 1961. It has been created uncertainty in the matter of taxability of compensation received on compulsory acquisition of the land, especially those to acquisition of non-agriculture land. The matter has been examined by the board and it has been hereby clarified. Compensation in respect of the award or an agreement which has been exempted from levy of income tax vide section 96 of so and so act shall also not be taxable under the provisions of Income Tax Act 1961, even if there is no specific provision exemption of such compensation in the income tax. This is the circular, my lord, issued by the the authorities under the income tax.
It only clarifies whether land acquired is agricultural or non-agricultural. Exemption is available. So that again is badly worded. It's not in taxation jurisprudence. It's some other English person has drafted.
My lord, thereafter, my lord, an amendment is made. My lord, proviso is added, my lord, to section 197.
CBDT circular because in
Income tax amendment.
ಅಷ್ಟೇ ಅಲ್ಲ. Whether acquisition is of agricultural land or acquisition of land which is converted to non-agricultural, or differentiation illa anta idra meaning.
And it is under this, and it is under 2013 Act.
2013 Act, that's what. That only says, again badly worded, yes, anything, we can make out something.
We have produced the circular also, my lord.
No, assuming that whatever, no, not you. We are only speaking about the ill drafting of the circular by the, at the hands of the CBDT. We are not on that. It only says section 96 does not differentiate between agricultural and non-agricultural. That's all.
Then, my lord, afterwards, my lord, an amendment is brought to section 194 LA.
We clarify what it says. Amendment says what?
94 LA.
Court of Sir, Income Tax Act. ಇದ್ರಾಗ extract ಮಾಡಿಲ್ಲ ನೀವು.
Page 1.11.
Flag ಹಾಕಿದೆ.
Saying?
It
What
says,
does it say?
provided further that no deduction shall be made under this section where such payment is made in respect of any award or agreement which has been exempted from levy of income tax under section 96 of the right to 2013 Act.
The deduction at source shall not be made. That's all.
That's all.
Nothing beyond that.
Under the 2013 Act.
That's all.
It says, my lord, 2013 Act. Again, we'll come back to, my lord, the same under this act.
Refer to section 194 LA of Income Tax Act. Refer to paragraphs 194 LA. ಆಯ್ತಲ್ಲ? ಅದು ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಷನ್ ಮಾಡಬಾರ್ದು, at source ಮಾಡಬಾರ್ದು ಅಂತಿದೆ. Beyond that there is nothing. These tax laws are very verbose.
The date is important, my lord. Kindly see the date on which, my lord, it has been made. Because I have submission to make, my lord, on that. 1/4/2017, my lord, is the date of inserting this provision.
194 LA is inserted with effect from 1/4/2017.
And that circular, my lord, of the finance department, my lord,
Must
is
be anterior to that. Otherwise, there was no need for that.
that is dated, my lord, 25/10/2016.
In the light of circular of the CBDT dated
25/10/2016.
25/10/2016. How that comes to your aid?
My lord, my another limb of my argument is, my lord, as on the date of passing an award, what was the law that is existing? To bind the SLO to pass an award, my lord, in accordance with law on that day.
No, this is clarificatory of the legal position. Supreme Court said in one taxation matter, where Parliament makes fiscal legislation clarificatory of the law, that applies with retrospective effect.
Lord, I am not on that, my lord. There was neither 2014 notification of the government, nor there was a clarification, nor there was an amendment, my lord, to this provision. The only provision that was holding the field was 96.
Correct.
Therefore, my lord, I am entitled for the benefit of 96.
96 has already given the benefit. So these are all clarified.
There was no law existing, my lord, as on the date of passing an award.
Noted. Any other point?
Therefore, my lord, the SLAO was bound by the provisions of 2013 Act, especially 96, which was made applicable because there was no law, my lord, of the state legislature, which is operating in the field. The entire field is occupied. Section 96 is applicable as on the date when the award was passed. The exemption, or
in other words, acquisition should be treated as having been made under the provisions of 2013 Act.
Yes.
Understood. But then,
my lord, there are
any other things?
There are judgments, my lord, of Andhra Pradesh High Court, Calcutta High Court, dealing with this 96, my lord, and they have, my lord, I have produced, my lord.
ಏನಂತ ಹೇಳ್ತಾರೆ? Just tell head, we'll go through.
96 apply ಆಗುತ್ತೆ tax exemption.
Acquisitions done under the legislation
National Highway
other than 2013 Act.
Yes. Beneficial legislation, no?
Judgment.
No, acquisition only under 2013 Act.
Lord, filed on 27/8/2024. There are two judgments, my lord, of one of Calcutta High Court and Andhra Pradesh High Court.
To be referred to the effect that acquisitions done under other legislations than 2013 Act are also entitled to invocation of 96 of 2013 Act. But those are under the Central Highways Act. National Highways Act.
Act was not applicable. National Highways Act was not applicable. 2013 Act is not applicable. Your lordships have seen Schedule 4. National Highways Act, my lord, this act was not made applicable to them. It was not repealed. Though it is a central legislation, it was not repealed. Under those circumstances, my lord, it has held that even though it is under those enactment, 96 is applicable.
We note that the acquisition was under the central legislation, namely National Highways Act.
Amal Nam High Court in Division Bench. Lord, it was in relation to KIDB. There, their lordships have held
against a bit against you.
No, in my favor. My lord, that is 96. My lord, repeal act, my lord, is pending in the Supreme Court. This was in relation to section 96. Saying, my lord, that 96, the benefit of 96 is applicable to, my lord, the KIDB acquisition made under the KIDB's Act.
Our Dr. Judge Dr. Kothari.
Illa. Their lordship Justice Barley, my lord.
That is under the Industrial Disputes Act.
96 is not applicable ಅಂತ ಅನ್ಕೊಂಡು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಓದಿದೆ ನಾನು.
Only in respect of part 4 and part 5 of the 2013 Act.
Part 4 and part 5, 96 ಬರೋದೇ ಅದರಲ್ಲಿ.
ಅವ್ರು ಹೇಳಿದ್ರು,
No,
in respect of part 4 and part 5 is applicable for the acquisition initiated under the National Highway Act for determination of compensation of the.
Not the exemption from tax ಬಗ್ಗೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
that was not the issue there.
That was not the issue.
Acquisition proceedings was question.
Referred to Krishna Kumar judgment.
But in spite of that, the
Krishna Kumar was single judge.
Single judge. Then matters.
Division bench, my lord.
Kale Saab and
Yes.
Kamal Saab.
MS Kamal.
Referred to DB judgment of Kale Saab and Kamal Saab.
even though it was not a issue, the court has dealt with the 2014 government order.
Which deals with the government order of 2014. Yes. Yes, sir. ನಿಮ್ದೇನ್ರ ಇದೆಯಾ? ಹೇಳಿ. ಊಟ ಮುಗಿಸ್ಕೊಂಬರೋಣ. 2:30 ಹೇಳ್ಬೇಕು, ಮತ್ತೆ ಟೈಮ್ ಕೊಡಲ್ಲ. ನಮ್ಮ ರಸದಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಜಡ್ಜ್ಮೆಂಟ್. Thank you, Mr. Chandrasekhar. Only we were a bit anxious to get more information, more jurisprudential thought from your side. From that angle, you view our language. Our language is not, my language is not that good.
I make once again request, my lord, if my lords get an opportunity, my lord, for issuing a suo motu writ of prohibition, my lord, against all magistrates, not to accept, my lord. Idrallalla.
But that's a great thought. We will definitely advert to. At least we can tell to those benches which are dealing these things. We'll make that.
Lot of time will be saved.
Judicial work
And
can be.
yes.
Time can be used for right things.
Police force cannot be used.
Used for this at all.
And my lord, the serving of notice is the last job for any police officer.
And instead of doing policing, they have to do all these things here.
How?
We'll put it to the concerned benches.
Yes. Obliged.
ಸರ್ ಇದನ್ನ ಸ್ನ್ಯಾಪ್ಸಿಸ್ ಪೇಜ್ ಹಾಕಿ ಕೊಡ್ತಾರೆ, ಪೇಜ್ ಇನ್ನೊಂದು ಸೆಟ್ ಎರಡು
ಇಲ್ಲಿ
ಎಲ್ಲ ಒಂದ್ರಾಗ ಸೇರ್ಸಾರ. ನೋಟಿಫಿಕೇಶನ್ ಡೇಟ್ ಸರ್ ಅವ್ರಿಗೆ ಇದ್ರಾಗ ಇನ್ನೂ
ಮೇಡಮ್ ಅದು ಬೆಳಿಗ್ಗೆ ಜೆಡಿಆರ್ ಹೇಳಿದ್ರೆ
ಇದಕ್ಕೆ ಇದ ಮನೆ ಫೈಲ್ ಮಾಡಿದ್ದು ಇದಾಗಲ್ಲ ಸ್ನಾಪ್ಸಿಸ್ ಒಂದರಿಂದ ಹಾಕ್ಬಿಡ್ರೆ ಈಗ 10. Seven, 58. ಇಲ್ಲ ನಾನು ಕರೆಕ್ಟ್ ಹಾಕೋತ ಬಂದಿದ್ದೆ. ನೀವು ಇದ್ರ ತಡ್ರಿ. ಇದನ್ನ ನೀ ಅದಕ್ಕೆ ಹಾಕಿ ನೋಡ್ರಿ. ಇದಾವಲ್ಲ ಸ್ನ್ಯಾಪ್ಸ್ 24 ಸೆಪ್ಟೆಂಬರ್ ಸ್ನ್ಯಾಪ್ಸ್ ಇದು ಇದನ್ನ 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 38, 40 ಪೇಜ್ ಐತ್ರಿ. ಸೆಕೆಂಡ್ ಸೆಟ್ಗೆ ಸರಿ, ಫಸ್ಟ್ ಸೆಟ್ಗೆ ಸರಿ ಆಗಲಿಲ್ಲ. ಇಲ್ಲಿ ಹಾಕಿ ದೊಡ್ಡಲಿ ರೌಂಡ್ ಅನ್ನ ಹಾಕಿ.
ಹಲೋ.
ಇವು ನಮ್ಮ ಇಲ್ಲೇ ಇಲ್ಲ.
investigation start ಆಗಿದೆ. Inquiry ಆದ್ಮೇಲೆ order pass ಮಾಡೋಣ. Cases create order pass ಮಾಡಿದ್ರೆ ಅವಾಗ investigation start. You should read this 17 PCR ತೆಗಿ. ಏನ್ ಹೇಳ್ತಾರೆ? ಈಗ ಹೇಳಿರ್ತಾರಲ್ಲ, ಈ ಮುಂದೇನ್ ಬಂತು? 17 There is a statutory vesting of the power of investigating. For exercising, protecting this is Article 7, the power of 17A is conferred under the 19th. He is not an authority. The entire jurisdiction must. Exclusive investigation agency the matter of Corruption Act. Matter of Prevention Act. Having regard to 63 Lokpal Act, read with Lokpal Act, read with Lokpal Act. The central line state line expressly 14 notwithstanding equal to inquiry and sanction or investigation. After a judicial order being passed by the Director of Parliament, fortunately being heard is also given to the accuser. Magistrate or a judicial magistrate or a session judge has no power to entertain a complaint under 200. Because exclusive jurisdiction is given to the factor. Field is also better. ಪೊಲೀಸ್ಗೆ 9 ಲೋಕಾಯುಕ್ತ ಇದ್ದಾಗ ಹೈಕೋರ್ಟ್ ಜಡ್ಜಿಗೆ ಹೇಳ್ತೀಯಾ? ಹೈಕೋರ್ಟ್ ಜಡ್ಜಿಗೆ ಹೇಳ್ತೀಯಾ ನೀವು? A session judge is directing a high court judge to register an FIR. Then 15
15 section 15 bagi staff of local he has no power. Local police has no power, independent power. Like before, police station. Police station declare ಮಾಡ್ತಾರೆ. Independent appointment of police officers and conduct investigation without depending on the state agency.
There is a prohibition, shall not investigate. During he feels very bad for having made mistake. You have fed a wrong question, you will get a wrong answer. If you have fed this question, do you think that you would have had there is a statutory vesting of the power of granting sanction. There is a statutory vesting of power. Sanction, permission, ಲೋಕಾಯುಕ್ತ ಬಿಟ್ಟು ಬೇರೆ ಯಾರಿಗೂ ಮಾಡಕ್ಕಾಗಲ್ಲ. ತಪ್ಪು ಲೋಕಾಯುಕ್ತನೇ ಹೋಗಿ ಗವರ್ನರ್ ಪರ್ಮಿಷನ್ ಕೇಳೋಣ ಐದು ಕೇಸ್ ಯಾವುದು ಒಬ್ಬರು ಕೇಸ್ ನಮ್ಮ ಬೇರೆ ಅಧಿಕಾರಿಗಳು ಬೇರೆ ಪರೀಕ್ಷೆ ಮಾಡಬೇಕ is the tragedy of our system. How you would take advantage of the investigation, whether you challenge it or make the police tell this or seek permission of the Lokaयुಕ್ತ to investigate. ಅಲ್ಲೇ ಹೇಳಿದ್ರೆ ಈಗ ಏನ್ ಹೇಳ್ತಾರೆ ಆಡಕೊಂಡು ಹೇಳ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ
2:30 ಅಂತ ಹೇಳಿದ್ರು. ಅಲ್ಲಿ ಈಗ ಬರೋದಂತ ಕಳಿಸ್ಕೊಡ್ತಾರಂತೆ. ಕೇಳಿ. ಸುಮ್ಮನೆ ಇವತ್ತು ಹೋದ ಮುಂದ್ರೆ ಮುಗಿತು. ರೆಡಿ ಇದೆಯಂತೆ ನಮ್ ಕ್ಲರ್ಕ್ ಹೇಳ್ದ, ರೆಡಿ ಇದ್ರೆ ಕಳಿಸ್ಕೊಡಿ. ನಾಳೆ ನಾನು VCL ಬರ್ತೀನಿ, ಇವತ್ತು ಹೋಗುವಷ್ಟು ಮುಗಿದ್ರೆ.
ಅದಕ್ಕೆ ಇರ್ಲಿ, ಆಯ್ತು ಹಂಗಾರೆ ನೀವು ನಾಳೆ ಬರ್ರಿ ಅಂತ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು. 2:30 ಅಂತ ಟೈಪ್ ಆಗ್ಬೇಕಲ್ಲ. ಹಲೋ, ಅವು ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ರೆಡಿ ಆಗ್ಯಾವ? ಅಲ್ಲ ಈಗ 2:30 ರೆಡಿ ಆಗಿದಾವಲ್ಲ? ಅಲ್ಲ ಈಗ ಎಷ್ಟಿದೆ ಅಷ್ಟಾದ್ರೂ ಲಿಸ್ಟ್ ಮಾಡ್ರಿ. 5-6 ಬೇಕಾದ್ರೆ ನಾಳೆ ಬೋರ್ಡಿಗೆ ಹೋಗಿದ್ಯಾ? ಹಾಂ ಸರಿ.
ಬರುತ್ತಂತ.
ಹಾಂ. ಸರಿ. ಇನ್ನು 5-6 ಇದಾವನ್ ಸರ್, ಅದು ಬೇಕಾದ್ರೆ ನಾಳೆ ಹಾಕ್ತೀನಿ. ಆದ್ರೆ ಹಾಕ್ರಿ, ಇಲ್ಲಾಂದ್ರೆ ನಾಳೆ ಹಾಕ್ರಿ.
ನಾಳೆ VCL ಬರ್ಬೋದಲ್ಲ ನಾನು?
ಹಾಂ VCL
ಇಲ್ಲಾಂದ್ರೂ
ಸೇಮ್ ಆಗಿದೆ ಅಲ್ಲ, ಗೊತ್ತಿದೆ.
ಬೆಳಿಗ್ಗೆ RP ನಂಬರ್ ಇದೆ.
ಬೋರ್ಡ್ ಅವ್ರು ಎತ್ತಾ ಇಲ್ಲ, ಬೋರ್ಡ್ ಅವರಿಗೆ
ನೋಡ್ತೀನಿ, ಕ್ಲರ್ಕ್ ಕಳಿಸ್ತೀನಿ.
ಕಂಟಿನ್ಯೂ ಬಂತ ನೋಡು, ಕಂಟಿನ್ಯೂ ಕೊಟ್ಟು.
Yes.
Lordship, leave, my lord. One or two facts, my lord, which my learned friend says, my lord, in all these matters, refund has been given, my lord, in pursuance of the order of the, ಈಗ ಹೇಳ್ತಾರೆ.
Reimbursement has been given.
Refund ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
No, that is because no stay was there.
You have refunded the money.
Because they also threatened us with contempt proceedings, and 3 contempt petitions were filed.
Under the threat of that, you had given.
Under the threat of that, yeah.
How that will not take away.
ಹಂಗೇನ್ ಹೇಳಿಲ್ಲ.
Anyway.
No, that is because the process.
ಬೇರೆ ಕೇಸ್ ಹಾಕ್ಲಾರ್ದವ್ರಿಗೂ ರಿಫಂಡ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಹಾಕಿದಾರಲ್ಲ, ಎಲ್ಲವೂ ಹಾಕಿದ್ದೀವಿ.
In fact, it has become infructuous, my lord.
ಇಲ್ಲ, how can it become?
On factualism.
And the senior advocate submits that the revenue having already refunded the income tax paid on the compensation to the land losers, comma,
in pursuance of the order of the learned singer.
In terms of the impugned order in the appeal herein, comma, these appeals have become infructuous. First, learned panel counsel appearing for the revenue in reply submits that merely by complying the order under the threat of contempt action, comma, the right of appeal does not diminish away. First, we agree with this. Yes.
Even those who have not filed writ petition.
Still it makes no difference because contempt was there.
In case of other land losers, in terms of, my lord, the government order or, my lord, 96, they have given to others who have not even approached the, my lord, this honorable court.
That senior advocate.
That may not be correct. Threat of contempt may not be correct.
Adds that. No, there was threat of contempt.
Lord, what I am saying, my lord, is
you have understood what you say is even in respect of cases where there is no threat of etc.
There is no writ petition, there is no direction.
Was not there, they have made it.
Yes.
I'll make a submission on that.
Chandrasekhar retorts that even in respect of other landowners who are not before the court, comma, the refund having been made, comma, the alleged threat of contempt fails into insignificance and therefore right of appeal withers away. First, we do not agree. The legal position being as clear as Gangetic waters in view of decision of so and so. Okay.
One other judgment, my lord, of Nagpur Improvement Trust Board.
Yes.
Which, my lord, the learned single judge, their lordship Justice Krishna Kumar and the division bench, my lord, have taken into consideration. That also, my lord, I press into service to drive home the point that there cannot be discrimination in the matter of paying compensation, my lord, treating, my lord, the landowners. That other one judgment is I have extracted, my lord. That may also be taken.
He also presses into service the division bench, single or divisional?
Supreme Court, my lord.
The apex court judgment.
Nagpur.
Very old judgment.
How do? 1973.
You have already said, na? Presses into service 1973.
73 1 SEC 500.
Which abhors discrimination of landowners in making payment of compensation.
Under different enactments.
Under several enactments. Your compensation ಮೇಲೆ ಎಲ್ಲಿದೆ ಇದು?
Compensation ಮೇಲೆ ಆ ಆಕ್ಟ್ ನಾಗ ಆದ್ರೆ ಇಷ್ಟು ಈ ಆಕ್ಟ್
ಅದಲ್ ರೈಟ್. ಇದು compensation ಕೊಡೋದ್ರಾಗೆಲ್ಲ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. ಇಟ್ಸ್ ಓನ್ಲಿ ಆನ್ ವೆದರ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಶುಡ್ ಬಿ
ಅಲ್ಲ ಡಿಸ್ಕ್ರಿಮಿನೇಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ 93 96.
This principle applies even in respect of levy of income tax.
Under section 96.
section, under section 96 of 2000.
It is universally applicable to all land losers.
Which should be made universally applicable to all acquisitions made under any statute. Okay. What is?
Lords, our main reliance is on the earlier judgment of this honorable court. And I may be permitted to read
Harish judgment.
Justice Kothari's. If I am permitted to read only some paragraphs. We have enclosed it along with our paper book.
11 to 15.
Our paper book at page 29. No, the same copy is with me. Refer to the inner page.
This was under Karnataka High Court, the Karnataka.
Same act.
Same act.
Same act. And it was under the BRTS scheme only. This is Dharwad Hubli scheme, the road project. Lordship will get at para 3.
Correct.
Petitioners for the purpose of road widening, creating such a BRTS.
Next.
So the court has considered section 27, 28 of the act. Then page para 11, 5. While categorically admitting the appellants are not against the said BRTS project, they have not pressed their prayer. That is not relevant. Para 11 onwards.
It is misconception.
It is a misconception of the appellant's petitioners that merely because the state government has adopted the yardstick or criteria for determining the market value of compensation on the basis of principles enacted in the new Land Acquisition Act in the government order dated 14/11/2014, and even same order, and even the addendum number 1 issued by the respondent HD BRTS Company Limited in November 2015, as envisaged and permitted under sections 103 and 107 of the Central Act and Act of 2013 itself became applicable to the present acquisition. It is the date of initial notification for the acquisition, like under section 4 of the old Central Act of 1894 or section 15 of the Karnataka Highway Act 1964, which is relevant to determine the applicable law. By government order dated 14/11/14 or addendum issued by the HD BRTS, neither the Central Act could be made applicable to the present land acquisition of 2012, nor it has been so done by the respondent state government. Therefore, the claim of the appellant that the Act of 2013 applies to the present acquisition and all proceedings for determining the compensation have to be undertaken accordingly is a misconception, and the same deserves to be rejected. We do not find any error in the findings of the learned single judge in this regard, repelling this contention. Section 24(2) of the Central Act has
Go to para 14 now.
Para 14, more relevant. On the other hand, the second contention of the appellant petitioners that the award deserves to be quashed because it was passed in terms of the provisions of the new Central Act falls to the ground of once we hold that the Act 2013 does not and cannot be applied to the present acquisition initiated in issuance of notification under section 15 of the Karnataka Highway Act way back in 21st November 2012, much before the commencement of the Act 2013 on 1/1/14, irrespective of the enhanced compensation awarded on the basis of policy decisions taken by the state government in the government order dated 14/11/14. The contention of the appellants that the policy decision, the Central Act was made applicable to the present acquisition is absolutely misconceived and is liable to be rejected by subordinate executive policy decision like the government order dated so. Neither the Central Act of 2013 could be applied to this acquisition, nor it has been so done. The legislative enactment has a place much higher than the such policy decision in the form of government orders. The policy decision to pay higher market value in consonance with the letter and spirit of sections 105 to and 107 of the Act 2013 Act does not ipso facto or ipso jure make the enactment of 2013 itself applicable to the present acquisition as a whole. The acquisition still continues to remain under the Karnataka Highway Act and continues to be governed by the provisions of the state.
What do you say? Suppose there is a, why can't we in the interpretation of 96, why can't we read it down to, because to save a provision, it's not put in challenge is one thing, but can't we read down a piece of legislation in the process of interpretation to make landowners land losers one homogeneous class? No judgment has considered all that. We are asking you now.
Article 13, my lord, is the answer. Segregating, my lord, the offending portion of the order, which it can be, my lord. Bengal immunity case, my lord, right from the beginning, my lord. The doctrine of eclipse, my lord, will come into play. If a portion of the order, if it is demonstrated to be violative of Article 14, my lord, having regard to the, my lord, Nagpur Nagpur Improvement Board case, my lord, my lords can read it down. Or, my
we are
lord,
asking you, our proposition is, can the doctrine of reading down be invoked where legislation is not put in challenge? What the law on the point? We are articulating it now for ease of reference. Can the Constitutional Court read down a piece of legislation in the process of its construction, even when its validity is not in question?
Immediately, I will not be in a position to, my lord, dry my hands, my lord, and place it, my lord. It is possible, my lord, in one of my case, my lord, the division bench of the Honorable, our Honorable High Court, the age restriction, my lord, for an ex-serviceman, my lord, it was number of years of service plus 3 years to be deducted while calculating the qualifying age for the recruitment to a PSI. I said
that was a case relating to rules of recruitment.
Yes.
Decided by Justice R.V. Ravindran.
Yes.
Where you had argued, I was on the other side.
Yes.
But that was not a case of, in fact, challenge was made to the rules. That was case relating to recruitment. KPSC was a party.
But the principal, my lord, is again invoking Article 13.
Correct. But
Segregate.
That question was not raised. We understand that. But we are asking you whether in the process of construction,
yes,
per se,
for meeting
there
ends,
being no challenge,
meeting ends of justice, my lord, it can be done.
That's what your argument is. Yes. But he will say no. Where do we stand? Unless you give some opinion juris or some ruling in support of this. Because that also, though you did not argue that, we felt after hearing you that incidentally this question, Mayor, of course, you have said that there cannot be discrimination, within that only it comes.
Yes.
To say, because presumption, right from the days of Ramakrishna Dalmia versus Justice Tendulkar, we have been taught in the law school that there is a strong presumption that a legislation is valid. Number one. Number two, the legislature understands the requirement of people and makes the law. Unless whether these presumptions can be rebutted in the guise of, purposive construction of the legislation, even when it is not put in challenge.
ಸ್ವಲ್ಪ time ಕೊಟ್ರೆ ನಾನು
ಅದೊಂದು ಮಾಡ್ಕೊಂಡು ಹೇಳಿ.
Lord, I have touched upon this, my Lord, in my written argument. It cannot be expected of a parliamentary enactment to be violative of Article 14. It shall always be presumed that the law made by the parliament is universally applicable to all sections of the society who are suffering from the acquisition of the land. I have stated in this way, my Lord. It shall be presumed that it is applicable to all persons. That under this act will not deprive the benefit of levy of,
In other words, under this act
has to go.
be amputated.
Yes.
Challenge is not before us.
Yes.
Therefore, question of the patient is not brought to the table at all. Operation theatre at all. Therefore, in the guise of construction, therefore we structured our question that way.
My Lord, we have said, my Lord, the deemed repeal, my Lord, even in the writ petition. Their lordship felt, my Lord, instead of going into this, 2014 notification is there, we will apply it, and therefore, in terms of 2000 notification, my Lord, is allowed.
We are not that happy with the treatment of the subject, because very larger issues you have raised.
Lord,
it will have repercussions, because once we.
ರಿಟ್ ಅಪೀಲ್ ನಲ್ಲೇ ಹೇಳಿಲ್ಲ ನಾನು, ರಿಟ್ ಪೆಟಿಷನ್ ನಲ್ಲೇ ಡಾಕ್ಟ್ರಿನ್ ಆಫ್ ಇಂಪ್ಲಾಯ್ಡ್ ರಿಪೀಲ್ ಅಂತಾನೆ ಹೇಳಿ, ವಿ ಹ್ಯಾವ್ ಸಾಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ದಟ್ ಸ್ಟೇಟ್ ಹೈವೇಸ್ ಆಕ್ಟ್ ಈಸ್ ಡೀಮ್ಡ್ ಟು ಹ್ಯಾವ್ ಬೀನ್ ರಿಪೀಲ್ಡ್.
ಅಲ್ಲ, repeal very well, we understand. Even without repeal, we are telling now. We are going one step further. We are not on repeal aspect now. Repeal aspect we will come to. We are only, we are just thinking.
Yes.
That to make the,
Lord, I have understood, my Lord. I will assist your lordship, my Lord, on that. On that aspect of reading down a provision to bring in conformity with Article 14, to extend the beneficial legislation to all land losers.
Beneficial legislation ಅಂತ ಅಷ್ಟೇ ಆಗಲ್ಲ. Of course.
Lord,
report
preamble note,
because everything 94
preamble ನೋಡಿದ್ರೆ, it was never even thought of, my Lord, rehabilitation, my Lord, and resettlement, my Lord, was the first time, my Lord, this was, of course, notifications were there. My Lord,
just give us one ruling, one judgment which says reading down doctrine can be invoked even when the constitutional virus is not put in challenge.
I will do that. I will do that.
Because Shirvai says in the 4th edition, ordinarily the judges should not go for invoking the doctrine of reading down, because how it should be read down will not be known to us. There is one paragraph on that doctrine itself.
Whether court can
read down a statute.
Read down statute is one aspect. Whether it is legislating.
He says it's a kind of legislating activity, because what Parliament did, we are cutting it short. We are amputating certain things.
Yes.
And doing this.
Yes.
And we just give that also.
But I will, on both the aspect, my Lord, it will not amount to legislation. It will be only segregating the wide portion of the order, which is violative of Article 14. And if it is done so, it is not going to affect any section of the society. On the other hand, my Lord, it is going to be benefited. It will be in conformity with Article 14. My Lord, I will do that.
We'll just look into it.
Yes.
See, law relating to acquisition has been enacted in several legislations. Law relating to acquisition is enacted in several statutes. A plethora of statutes have such provisions. If acquisition is made under the provisions of those statutes, compensation payable is also less, plus they have to make the payment of income tax. That's the fact. In fact, it's so obvious it is. Whereas if acquisition is made under the 2013 Act, compensation is 3 times, 4 times the compensation payable under the other statutes. And still you are giving the benefit of income tax. Exemption, not exemption, you don't levy the tax at all. Okay. In that very blatant discriminatory situation, the Constitutional Court read down section 96.
Well, unless the act itself is made applicable to the acquisition under the Highway Act.
No, that becomes applicable once we are just putting this question
Yes.
because he has argued that. Section 2, clause 1, read with 107, 108, 109. That gives an impression that this legislation occupies the field, and therefore, because the state has obtained assent under 254, and this legislation is post-assent legislation. 2013 is post-assent legislation. If that is so, suppose if we hold all acquisitions would be deemed to be under, it's not that if they are repealed, it is not that. If those sections in various legislations, more particularly Karnataka High Court Highways Act, are repealed, it is a case of non-liquid. Non-liquid means a situation where there is no statute. There will be statute, namely 2013 Act. What's your answer?
Well, similar instance had come up under, insofar as the ID Act, Industrial Development Act, and the applicability of Article 254. This court has negatived that. Saying that Article 254, it doesn't violate Article 254 for the main reason that it falls under different entry in the.
Correct.
One of the reasons that it falls under.
No, we have understood that.
So where is the same challenge under Article 254 in respect of ID Act has been negative.
It also provides for acquisition.
It also provides for
Which section?
Karnataka Industrial Development Area.
Industry, KADB.
KID
Act.
KID.
1966 Act.
Yes.
Intends to place this act wherever acquisition of land is to be acquired. Near the ಅಲ್ಲಿ within substance very incidentally these are all which is that judgment?
That is judgment in Padmanabhan versus State of Kerala and others. It is under the Kerala Act. 2018 4 SCC 537, AIR 2018 AIR SCW 2982.
Now, doctrine of reading down melon judgment, the recent past.
That is, I'm sorry.
Read into it. Correct. Read into it. Correct. That compassionate appointment ಅಲ್ಲಿ
Legislating only.
perhaps I have put it compassionate appointment ಮೇಲೆ
This is more Mallikarjunayya and others versus Union of India and others.
The legislative scheme itself.
Padmanabhan. ಅದ ಈಗ PCCR.
ನಾವು ಪ್ಯಾರಾಗ್ರಾಫ್ ತೊಳಿ ಈ ಜಜ್ಮೆಂಟ್ ಓದ್ಕೊಂಡು ಹೇಳಿ ನೀವು ಓದ್ಬಿಡಿ ನಾವು ಕೇಳ್ತೇವೆ ಎಲ್ಲರೂ ಕೋರ್ಟ್ನಾಗ ಇರೋರಿಗೂ ಗೊತ್ತಾಗ್ತದೆ.
Sorry, I just cited an Education Act. That is the Kerala government took over all the schools that context, whereas the Pay ID Act is a different.
Okay. Not incident. Creation is one of the incident.
Development. It has to develop, this one you need land. Any other contention you want to add?
Yes, my lord. Section 105 of the Right to Information Acquisition Act of 2013, it is clearly said that in respect of compensation, there should be a notification issued by the central government, even in respect of compensation.
105.
There is no notification.
105.
105.
That was in respect of central act. Chandrasekhar read that fourth schedule statutes. Fourth schedule statutes are all centralized.
Centralized, no doubt.
Them, if you want to do, the notification is.
Notification has to be issued. Even in respect of National Highway Act, there is no notification I am submitting. And even if it is a submit, even if it is accepted, it is only for a compensation. If it is only for this purpose of compensation, not for the any other provisions.
Section 103, 104, 105, and 106. No, 103 in the 103 to 108. Refer. Of the 2013 Act.
And in this regard, Justice Vinit Kothari again has held, while sitting single in Tippeswamy and others versus Union of India and others, 2018 4 KLJ.
ಸುಮ್ಮನೆ ಕೊಡ್ಬೇಕು ನಮಗೆ ನೀವು ಅಲ್ಲಿ ಎಲ್ಲೇ ಒಂದು ಯಾವ್ದೋ ಆಥರ್ ಬರೆದಿದ್ದು ನಂಗೆ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ ಅವನು ನಾನು ಹಾರ್ವರ್ಡ್ ಪ್ರಾಡಕ್ಟ್ ಇರಲ್ಲ.
Listening to argument, listening to an argument is much different from reading the. So all their written submissions, in fact, we could.
You have given written submissions long ago. 24/9 was the latest one.
So my submission is that even under Article 254 will not apply to override the Karnataka Highways Act, because it is not, there is no conflict between the 2013 Act and 2000 the Highways Act, Karnataka Highways 1956. So therefore 254(2) will not have any role to play in this provision.
That panel council submits. That panel council submits. Article 254 is not invocable in the present case at all, since there is no conflict between the policy content of two statutes, namely the 2013 Act,
Whether it will
which
apply.
employs the term acquisition under this act, will include acquisition done under other legislations also is one aspect. Because of 2013 Act, entire law relating to acquisition is now exhausted by the central legislation. Therefore, the provisions of various legislation, state legislation, maybe central legislations also, all they stand impliedly repealed because of proviso 254(3). ಇಷ್ಟೇ ಇವೆರಡು ಪ್ರಿನ್ಸಿಪಾಲ್ ಕ್ವಶನ್ ಆಗ್ತದೆ. ಅಂಡ್ ದಿ ಅದರ್ ಥಿಂಗ್ಸ್ ವಿಲ್ ಬಿ when you treat landowners as one homogeneous class because they contribute to the agrarian policy ಇರೋದಕ್ಕೆ.
Even income tax treated them as one class. Land losers under any enactment as one class.
ಹಂಗಾಗಿ ಇಲ್ಲಿಯೂ ಸಹಿತ ನೀವು ಡಿನೈ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಎರಡನೇದು ಜಸ್ಟಿಸ್ ಆಸ್ಪೆಕ್ಟ್. In so many words we may not say. Cardozo says the decisions are made at the rock bottom of the heart and they will have a lot of emotional elements, the sense of justice, etc. ಅದಾದ್ಮೇಲೆ ಅದಕ್ಕೆ ಬೇಕಾಗೋ ರೀಸನಿಂಗ್ ಎಲ್ಲ ನಾವು ಆಮೇಲೆ ಕೊಟ್ಕೊಳ್ತೀವಿ ಅಂತ ಬರೀತಾನು. The nature of judicial process, very famous book, and the growth of the law, two very famous books which he has written. He says that way. Therefore, ಅವರಿಗೆ ಕಡಿಮೆ ಕಾಂಪನ್ಸೇಷನ್ ಪ್ಲಸ್ ಡಿಡಕ್ಷನ್ ಆಫ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್, ಇವರಿಗೆ ಜಾಸ್ತಿ ಕಾಂಪನ್ಸೇಷನ್, ನೋ ಲೆವಿ ಆಫ್ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಎಟ್ ಆಲ್. ಈ ಡಿಸ್ಪೇರಿಟಿ, how you are going to address that disparity?
But why didn't the parliament address this point, Lord? That is the issue.
It should be raised in the parliament, not in the court hall.
Lord, I have also addressed, my Lord, on the question of Article 265. If disallowance of income tax on acquisition is specified under that, is there any other class which has been subjected to levy of tax under Article 265? Income Tax Act says land losers under any enactment.
No, that for limited purpose.
That is for capital gains.
ಅದರಲ್ಲಿ ಹೇಳಿದ ಮೇಲೆ Article 260, unless it is, my Lord, authorized by, my Lord, in law, where is the authorization to levy tax on the land losers other than 2013 Act? Lord, I have dealt with that also, my Lord. There has to be a law authorizing the income tax department to levy tax other than acquisition under 2013 Act.
Okay.
There is no law.
Income tax Act,
Capital gains tax.
the tax, the incidence of tax is
My
income.
Lord, when income tax says all acquisition, 190, my Lord, 194 AL naga, they say all acquisition.
But that has to
And
be
section 9 and one section, your Lordship will kindly see, my Lord, 96 says no levy on acquisition.
under that act.
My Lord, is there any law by the parliament saying that income tax will be levied in respect of acquisition other than 2013 Act? There has to be a levy, my Lord, a legislation to levy income tax under 265, to sustain under 265.
It is levied under the Capital Gains
Section
Act.
96
Yes.
is in the nature of an exception to some provisions in the Income Tax Act, 1961. In the absence of 96, whatever usual levies that are done under the 1961 Act would continue to be levied only.
It is a capital gains tax.
I not
Capital levies.
Capital gains tax.
Lord, can I put it in this way, my Lord? Section 96 says no levy on acquisition.
No levy on transfer compensation accruing by way of compulsory transfer.
How?
Under 2013 Act.
Is there any law saying that compensation?
Because of the cutoff day, from that date onward, it becomes capital gains only.
there has to be a law by the parliament authorizing the revenue to collect a tax in respect of acquisition under ABCD.
Not
In the absence of 265 compliance, Lord, seeking for enforcement of, my Lord, 194 AL, my Lord, will be hit by Article 265.
There is already law on that.
Lord, that I have dealt with, my Lord, in my written submission.
The senior advocate submits that there is no law that authorizes levy of income tax on the class of land losers which otherwise do not fit into the scope of 96 of the 2013 Act, and therefore there cannot be any levy at all because no levy sans legislation in
Under
view of
265.
265 of the Constitution.
The provisions of Income Tax Act.
Panel counsel submits that the compensation payable on account of acquisition is treated as capital gains, and therefore usual provisions levying tax are attracted. Reading
ಅದರಲ್ಲಿ 294 ನಲ್ಲಿ ಎಲ್ಲಾ ಲಾ ಅಂತ ಹೇಳ್ತಾರೆ. ನಾನ್ ಲೆವಿ ಹೇಳೋದು ಬರೇ 96 ಅಂತ ಹೇಳ್ತಾರೆ. ಅದೇ ತರ ಪಾರ್ಲಿಮೆಂಟ್ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಅಂತ ನಂದು. Parliament should have legislated authorizing the revenue to collect income tax in respect of acquisition under the other provisions, because 194 says all other enactment.
Once there is a statute in place, namely 1961 Act. In the absence of 96, your whole case is 96 should be the umbrella under which, of course, it appears to be the leaking umbrella, is another thing, under which you are seeking refuse now. You are seeking refuse under the umbrella of 1996 by your ingenious argument. In the absence of 96, you are in the reins. You are completely under the torrential reins. That is the premise on which you have built your argument. Whole case is built that way.
Therefore, my lord,
because there is a
levy of income tax in respect of other legislation, there has to be a legislation in compliance with 265 is my responsibility.
Because there is a levy, there is an exception under 196. Otherwise, if 96, there is no levy, 96 will not be there at all.
To some extent, reading down, we have treated in one matter.
Yes.
Just look into it. Para 6 may be read. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
Lord, the same principles are there, my lord, in cellular, Tata cellular case also, my lord. This appears to be the line of, my lord, invoking the doctrine of reading down.
We refer to Thomas Cooley,
yes,
the American author. Then we structure that way to suit to Indian condition. Constitutional Limitations by Thomas Cooley.
I will work on it, my lord. And
just work on it.
Yes.
Heard result. Thank you so much to both of you. Same. List number 4 agattala. Same.
List number 4 by V. Raviraj.
No, one aspect is that first appellant.
ಅವ್ರು ಕರೀರಿ. ಚಂದ್ರಶೇಖರ್ ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅವ್ರು ಹೋದ್ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ?
Given it in the submission. The
ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಏನೋ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನೋಡಿ.
The first appellant has suffered an order, assessment order. Usually under TDS is only deducting. It is up to the assessee to claim refund also. Insofar as TDS is concerned, we are submitting that TDS is only a deduction of the tax. It doesn't become tax. It is sits as a credit to the assessee.
Becomes tax after the assessment.
After the assessment. In the first assessment, first appellant's respondents Tushira Industries, the assessment order has been passed. And over that he filed a appeal, first appeal, and the first appeal was dismissed. And after that he has availed the benefit under the Vivad Se Vishwas scheme. And he has filed a form 5. He has filed form 1 and we have issued a form 5 also saying that it has been accepted. So any amount or any order passed also will not get away, he cannot avail any refund.
Why?
Because he has already availed the benefit.
Reject your petition, your appeal.
Yes.
Is he not entitled to everything that has been
Wrongly, 265 will apply.
He will be. That's how courts have held. I think even in Vodafone's they have said that.
Yes. So, but we have taken that content. He has already availed the benefit. And even if we succeed in the writ appeal.
Because your income tax department is more fearsome than the police department. Therefore they do something. Headache bad namge antar.
Already here they have filed 3 contempt matters here, and Mr. Anil Kumar is aware of it. He is the advocate who has
But
filed.
to others also you have given antar. Problem.
Now, what has happened? That I will clarify, my lords. Many assessees file returns. They claim refund. When many ITOs would have given it.
No, why you?
It is not that the ITOs.
We have said we don't agree. It's not that order. It's only notes.
No.
You have already refunded the tax component to those who are before the court and to those who are not before the court.
Before the court we filed, we have given because we did not enjoy a stay.
Why you made refund to others?
Others we not given on this judgment. The ITOs might have given the order.
It was only your clients only.
No, I am submitting that those orders are amenable for revision also.
Well, you have not filed any revision.
No, it's not here, my lord. The CIT can revise it.
No, that advisor, it may happen.
No, it may happen, it may not happen. Many cases they go like this.
Fact remains that whether because your contention that we have made the payment because of threat of contempt, that may not be true.
Lord, we will file a memo, my lord, let him take instruction in the cases where they have not filed writ petition, but still they have refunded the tax collector.
Then we will review that. We have a power to review that if it is within the limitation.
Once there are judgments which B.L. Hansaria in his treatise on writ jurisdiction has enlisted 3-4 judgments saying once an order is voluntarily complied with, ordinarily no right to challenge that order accrues. There are such judgments which B.L. Hansaria in his book, very good book, very old book, needs revision. That's another thing that he gives list of cases.
But we have not given it voluntarily. We have given it because.
Yes, my lord, we will file it.
Tushira Industries we have not paid. And Berori Kotidre because that is assessing officers would have given it. Judgment. There are so many petitioners there. We wouldn't have given to them.
Verify Madi, those who are not before the court.
There is a writ petitions pending before the Gulbarga High Court also. On the same lines.
Now, ಇಲ್ಲಿ ಧಾರವಾಡದನ್ನೇ ಹಾಕಿ ಒಂದು ಮೆಮೊ ಹಾಕಿ ಕೊಡ್ತೀವಿ, let him take instruction.
That's what. Correct.
Yes. Let him take instruction, my lord.
Yeah. Pattella ಆದ್ಮೇಲೆ whether we should examine, then all other examination would become academic.
The many people have also suffered the tax. That is not as though that only everybody have availed the benefit.
My lord, this has
So many
become a
cases-
contentious issue, my lord, not only in our high court.
No, so many
but
wrong
other high
judgments,
courts also.
wrong orders may also have been
My lord,
passed
it
by them.
requires to be considered, my lord, threadbare, my lord, in accordance with law, so that there will be, my lord,
Clarity of law.
end to this, my lord, anomaly. And there is also, my lord, I am told, thinking, my lord, in the income tax department, that they should not hesitate in refunding the amount, because in the spirit of 96, to all person in respect of all acquisition under the any other enactment. Because Government of India also issued a notification, we have produced along with our synopsis, my lord. Government of India also issued a notification in terms of 2014 notification in respect of acquisition in other enactments also.
Other enactments. ಹೌದು. Fourth schedule ಆಗಿ central legislation ಮೇಲೆ. Fourth schedule legislations. ಹೌದು, ಅಲ್ಲಿ legislations ಅಲ್ಲ.
Even though act is not applicable to them, 2013 act is not applicable to them. But still a notification similar to 2014 has been issued. And income tax exemption, my lord, is also given to them. Refunds have also been directed to be given.
But different enactment.
National Highways Act.
Because central act.
ಹೌದು.
Fourth schedule act.
That is not part of 2013 act. National Highways Act is not part of 2013 act.
But once it is brought on to the fourth schedule, other reflections begin.
My lord, there was a direction to bring on par with, my lord, 2013
This legislation,
act. Yes.
because that's the parliamentary injunction.
My lord, to my knowledge, my lord, there is a challenge, my lord, to the national acquisition of lands under the National Highways Act. Unless you comply with 105, you are not entitled to
acquire
operate the National Highways Act. Because you have failed to bring in within 1 year the provisions on par with 2013 act. Yes.
Parliament ಹಂಗೆ ಹೇಳೋ ಬದ್ಲಿ ಅವರು 2013 act ನಲ್ಲಿ we have brought it on par ಅಂತ ಮಾಡಿಬಿಟ್ರೆ ಆಗಿ ಹೋಗ್ತಿತ್ತು. There was no need for injunction by the parliament.
Lord,
because fourth schedule, of course, many aspects are there, but we felt like that in one matter which I decided 2019. We were the reported judgment which F.E. Patil had argued 2019. This one. Anyway, let us see that aspect also. Thank you so much for that result.
Pass over matter number 5. Bakar Ahmed. Bakar Ahmed.
ಎಲ್ಲಿ ಹೋದ್ರು ನಿಮ್ ದೋಸ್ತ? ಹಾ ಹೇ
है सर, बाहर है.
Madam is addressing court hall 4, my lord, so we were waiting for her.
What happened to you?
Some
ಏನಾಯ್ತು?
ಸ್ವಲ್ಪ ಅವರು ಮಗುಗೆ
Check ಮಾಡಿದ್ರಾ?
Yes, yes. ಸ್ವಲ್ಪ familiarity ಆಗ್ತಾ ಇದೆ, my lord. So I seek this right may be given to some extent. ಸ್ವಲ್ಪ ಮಗುವಿಗೆ ಭೇಟಿ ಆಗೋಕೆ ಅನುಕೂಲ ಮಾಡಿ.
ಹಬ್ಬ ಮುಗಿಲಿ, ಹಬ್ಬ ಮುಗಿದ್ಮೇಲೆ ಹಾಕೋಣಂತೆ. ಕಾಲ್ ಇನ್ ದಿ ಸೆಕೆಂಡ್ ವೀಕ್, ಥರ್ಡ್ ವೀಕ್ ಆಫ್
ಭೇಟಿ ಆಗಕ್ಕೆ ಸ್ವಲ್ಪ ಅವಕಾಶ.
ಕನ್ಸಿಡರ್ ಮಾಡಿ. ಆಯ್ತಲ್ಲ?
Yes.
ಅಲ್ಲೊಂದು ಸೆಂಟೆನ್ಸ್ ಬರೀಬೇಕು. ದಿ ಅಪಲೆಂಟ್ ಫಾದರ್ ತಾನೇ?
Yes, sir. Yes.
Appellant,
Appellant
father. Appellant father, with the leave of God, happily interacted with the child in the presence of Srimati Vidyavati Kottur Shettar, M. Kottur Shettar, whom had requested to be around. Full stop. Call this matter the third week of October 2024. But there is a larger issue which the gentle lady has raised. You have married?
Yes.
She has married.
Yes.
Minor child by normative process will be on the lap of the mother because it's a girl child, minor child.
Even
She whispers into the ears of that child that the new husband is your father. And father treats that child as his own. Now, if she tells the child, no, this father is not your father, but the other person is your father. What all the belief system that may get affected.
Right.
So think on that direction also.
Even
Okay.
in
Madam has addressed the
Whatever,
issue,
whatever
stating-
your Islamic law may say, many aspects are there. After constitution has come, constitution is everything for us.
even in
Nothing
the,
else is. Yes.
even in the agreement of Kulalama, he has agreed to upbringing of the minor female child with the mother.
No,
He has
that is
agreed for
custody.
that.
Custody.
Custody as well as upbringing.
Has he
He is
given up
agreed.
vegetation rights?
Education and,
Vegetation rights.
yes,
Has he given up?
not given up.
But even if he has given, he's a father. He's a biological father. He's a marital father.
After
Oh.
some age.
No, it requires a deeper examination. Adi,
My lords,
Adi,
ನನಗೆ ಮತ್ತೆ ಯಾವಾಗ
we appreciate the assistance rendered by Srimati Vidyavati. Okay. Registry to share a copy of this order with her.
ನನಗೆ ಮತ್ತೆ ಸ್ವಲ್ಪ ಭೇಟಿ ಆಗಕ್ಕೆ ಅವಕಾಶ ಕೊಡ್ಬೇಕು. ಮತ್ತೆ ಸಂಡೇ ಯಾವ್ದಾದ್ರು ಅವಕಾಶ ಮಾಡಿಕೊಡ್ಬೇಕು.
Vacation ಆದ್ಮೇಲೆ ಬರೀ ಎರಡು ಸಂಡೇ ಬರುತ್ತೆ ನಡುವೆ ನೋಡೋಣ. Because let us see. Call this matter in the third week of. Okay.
6, Sadiq Goodwala.
Yes. Complaint.
Complaint? Illa.
My lords, for cancellation of sale certificate. But after the auction purchase, the sale certificate is issued in favor of the auction purchaser, that is accused number 3. But he has to submit the original to the bank.
Who?
The auction purchaser.
ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ಅದನ್ನ ಒರಿಜಿನಲ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳ್ತೇವೆ ನಾವು.
Because that
ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿದೆ? ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿದೆ?
Lords, as far as my lords, the original lords is given to the auction purchaser, the sale certificate. Now, as far as the title deeds of the property are concerned, the title deeds, my lords, there is a original application pending in the DRT Bangalore, wherein, my lords, these original documents have been submitted there. It is the dispute is between this bank and the same complainant. The complainants, my lords, have taken some other loans.
ನಾನು ಅವ್ರ ಕಡೆನೂ ಕೊಟ್ಟಿದ್ದೆ ಸರ್ ಬ್ಯಾಂಕಿಗೆ ಕೊಟ್ಟಿದ್ದೆ.
ಹೆಂಗ ಯಾವಾಗ ಕೊಟ್ಟಿ? ಹಂಗ ಅಂದಾಜಿಂಟ್ಲೆ ಮಾತಾಡಬಾರ್ದು. ವೆನ್ ಡಿಡ್ ಯು ಗಿವ್ ದಟ್? ದಿ ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡು
ಹಂಗ್ ಮಾತಾಡ್ಬೇಕು. ಏನಾರ ಒಂದು ಬೇಜವಾಬ್ದಾರಿಯಿಂದ ಮಾತಾಡ್ಬಾರ್ದು ಕೋರ್ಟ್ನಲ್ಲಿ. ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಫಾಲೋ ಆಗ್ತದೆ. ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್ ಈಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಹ್ಯಾಂಡ್ ಬ್ಯಾಕ್ ದಿ ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್, ದ ಒರಿಜಿನಲ್ ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬ್ಯಾಂಕ್ immediately. First, call this matter, and the bank on receiving the same.
Cancellation apply ಮಾಡಬೇಕು.
Shall ಅದು ರಿಜಿಸ್ಟರ್ ಆಗಿದೆಯೇನೋ?
ಇಲ್ಲ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. We will cancel it.
ಒರಿಜಿನಲ್ ಇಲ್ದನೂ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬಹುದು.
The bank shall cancel the
ಒರಿಜಿನಲ್ ಇಲ್ದನೂ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬಹುದು. ರಿಜಿಸ್ಟರ್ ಆಗಿಲ್ಲ.
They have to not submit the original.
Cancel ಮಾಡಬೇಕು. ರಿಜಿಸ್ಟರ್ ಆಗಲಿದ್ರು it's
original document, my lord.
Instrument.
Yes, by the zonal, not by the branch manager, but by from the zonal office, my lords, it will be cancelled.
The bank, on receipt of the same, the bank shall cancel the said certificate and invalidate the transaction which was brought about by it, so that the interest of the complainant is restored in the property. The interest of the complainant to the property is restored to him. First, all this should be done within 2 days. Call this matter on Monday.
Please.
Tuesday. First.
Tuesday. It takes 2 days time, lords, if he submits it today or tomorrow. In 2 days time, that is by Monday or Tuesday, lords, we would have passed the order.
If the certificate, if this order is not complied with by the auction buyer and by the bank, stringent action against them and the officers of the bank would follow. Please. Against him and against officers of the bank would follow. Please. Call this matter on sides. Or you could put it. Or a copy of this, the carbon copy of this order should be handed to all the advocates appearing for the parties. Okay. Ready, Mashuman, put.
Final hearing matter. 29. Shikala Desai.
I filed a calculation memo, Your Lordship.
Application.
Please, Your Lordship.
30. SV Aji. 31.
Same application.
32. RB Halli.
Serial number 30, only calculation have been made, my lords.
Vacation. Calculation can be made even after vacation. Mathematics does not die after the vacation.
No, liability is in question. Liability is in question.
Question.
32. RB Halli.
All applications.
Admission matters. 35. YB Raviraj.
Appear for response. Not possible today. We are in the mid of parted matters, 3 matters, the full reserved matters.
Yes.
So we have to wind up on Monday, Tuesday. So take chance before some other judges, some other bench. One the date held, the other one date one. Choose some date from the calendar.
Yes, can it be in November sometime if it's not too inconvenient?
Held, the other one date held.
It is only Thursday.
Thursday.
Only Thursday. First week of November.
In the first week of November 2024.
Thursday, which date it will be? Just
A week hakkoli.
First week of November.
okay. Obliged.
Yes.
36.
Not reached and high. Not reached and high. Not sign not reached.
36. 36 appear for the appellant. Respondent is unrepresented. It can be disposed of. May not take more than 2 minutes. May not take more than 2 minutes. Served unrepresented. Contesting respondent. Lord, this case, well,
Application.
please.
Sir, 6th. Cell number 6 ಕಾಪಿ ಕೊಡ್ತೀರಿ ಇಲ್ಲೇ ಕೊಡ್ತೀರಲ್ಲ ನಾವು ವೇಟ್ ಮಾಡ್ತೀವಿ ಬ್ರಾಂಚ್ ನಲ್ಲಿ ತಗೊಳ್ಳಿ ಓಕೆ
Sir, 44 serial number. After vacation.
ಇದು ಒಂದೇ ತೊಂದರೆ ಆಯ್ತು